in the Army, and the plane hit right where his office was, and it's a miracle that he survived. He's had over 50 surgeries, and we're so honored to have Senator Birdwell, Lieutenant Colonel Birdwell, with us today, and his wife Mel, who he spoke to, who didn't know if he was alive or not. No communications for hours and hours until later in the day. So Mel, we know you're watching, and we're with you as a body as well. You all may be seated. Members and council, before we begin, I'd like to go over the clock and a reminder of the schedule ahead. Beginning today, the time remaining for the House managers is 14 hours, 28 minutes, and 17 seconds. And the time remaining for respondent, 14 hours, 23 minutes, and 17 seconds. That means, and we plan to go till 6:30 or 7 tonight and tomorrow night, possibly Wednesday. And since both of you have been almost even in direct and cross-examination, redirect and recross, that you both have about the same amount of time. And so based on that time schedule, both sides will be likely down to under 5 hours by sometime late Wednesday, depending on how the time is divided. And both sides could be out of time on Thursday morning. I want to be very clear that one side or the other could have time left that the other could not respond to. Those are the rules that both sides proposed and agreed to. So it's up to you to strategize and manage your time properly. But when you're at the end of the time, I'm not going to cut you off in mid-sentence. We'll give everyone ample notice. You have an hour left, 30 minutes left, 15 minutes left. But there will not be, I need another half hour, I need another witness, I need a few more questions. When the time is up, the time is up. And then you'll have an hour for rebuttal, and you'll have an hour for your closing arguments beyond that. That means, members of the jury, you may have this in your hands late Thursday or Friday. We will not take a day off until a final resolution. Whether you deliberate a short time, mid-time, long time, we'll stay here through Friday, Saturday, Sunday, Monday, until you've made a decision on every article that you're prepared to come and vote. So from this moment forward, no off days until the trial and the deliberations and the decision is given. With that, call your first witness.
We call Mark Penley.
Bailiff, please bring in the witness. Mr. Bentley, please step forward. Did you take the oath the other day? I have not taken. All right. You don't have to repeat after me. You can just at the end answer. Please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth. So help me God. I do. Please be seated.
Good morning.
Good morning, Mr. Hardin.
I want to warn you now, each of us needs to be a little bit closer to the microphone than you are right now. I think that bass actually does move if you want to move it towards you a little bit. If it doesn't, don't force it. All right. If you would just keep that in mind, please, because we have some acoustic issues. State your name, please.
My name is Mark Penley.
Mr. Penley, how old a man are you?
I'm 69.
Where did you grow up?
Grew up in Denton, Texas.
And when you high school, college, give us a little bit, like a minute and a half or so if you can.
All right. Went to Denton High School, graduated in 1972, played high school football, president of the student council, was in the Fellowship of Christian Athletes, went to church and Sunday school and sang in the youth choir at the First Baptist Church. I was in Boy Scouts and was an Eagle Scout. And
let me stop you there. Let me just try to do some of it, if I can, by question and answer, rather than just a narrative, which I first asked for. If you'll keep in mind, you started talking fast. You're an interesting combination. You talk slowly, but you talk fast, if that makes any sense. So just stay with me long enough for everybody to be able to hear you. After high school, and I think you folks are Eagle Scouts, y'all stay pretty close together, do you not, in terms of later in life or so, if you stayed active with them at all?
Well, I didn't. After I attained the rank of Eagle, I was busy playing football and doing other things, but certainly something I was very proud to attain.
Mr. Penley, you mentioned religion. Would you describe for the jury in your life what role religion has played?
Yes, sir. I'm a Christian. My belief in Jesus Christ is the most important thing in my life. He guides me in everything I do. He's my strength. He's the cornerstone of my life. And I try my best to honor him in every area of my life.
Was there a particular moment in your life that you particularly saw the road ahead for yourself?
I did. I grew up going to church, and I thought being a Christian meant being good. But in 1968, in the summer, I went on a school trip to San Antonio, and there was a man by the name of Billy Graham having a crusade at Alamo Stadium. And for the first time in my life, I understood the gospel. We can't save ourselves, but Jesus died to save us, and I put my faith and trust in Christ that night.
Mr. Penley, those of us, like myself, that grew up in North Carolina are very familiar with Billy Graham. From then on, and I want to ask you if we can make our answers short and to the point of the question, but from then on, from the time you were 14, was your religion a very, very big, integral part of your life?
Yes, sir.
All right. And then what about politics? Did you at any time in your education and early careers become interested in politics?
Well, I've always been interested in politics. My father was. He was active in local Republican politics in Denton County. He was the county chairman for Senator John Tower.
All right. So throughout your career, this is not probably a favorable point for Democrats, but might be interesting to Republicans. Have you ever voted for a Democrat in your life? Yes or no?
No, not to the best of my recollection.
All right. Not on purpose? You mean you might have accidentally done it?
Well, I might have voted for a judge.
All right. Okay. Now, let me ask you, so high school, where did you go to college?
I went to the United States Air Force Academy.
Did you serve all 4 years?
Yes, sir. I stayed all 4 years.
And then how long were you in the Air Force?
I was on active duty for 5 years in the Air Force.
After Air Force, you were how old when you graduated?
I'm sorry, could you say
How old were you when you graduated from the Air Force Academy?
I was 22.
What did you do then?
Well, I went on active duty and I became an aircraft maintenance officer and primarily stationed at Reese Air Force Base in Lubbock.
All right. Then after your service, how many, I think you said, but how old were you when you got out of the Air Force?
I was 27.
What did you do then?
Went to law school at the University of Texas.
When did you graduate?
1984.
What did you do then?
I took a job at Andrews & Kurth in Houston in commercial litigation.
Andrews & Kurth at that time was one of the 3 or 4 largest firms in, one of the 4 or 5 probably, largest firms in Houston, was it not?
Yes, sir.
And how long were you at Andrews & Kurth?
I stayed there 4 years.
And then what type of practice did you do?
A general commercial litigation practice, a little bit of tort litigation as well.
And then after your time at Andrews & Kurth, where did you go?
I transferred to Strasburger & Price in Dallas, I wanted to do more trial work, and I felt like I'd get more opportunities there.
How long were you at Strasburger and Price?
I stayed there 13 years, I believe, from the fall of '88 till January of '03. So about
While
14.
you were at Strasburger and Price, did you meet Mr. Ken Paxton?
I did.
And how was that? How did you meet him?
Well, he was a fellow associate at the law firm. He got there a year or two after I started, and we met each other and had some similar interests and knew each other a little bit.
And so how long were you at Strasburger and Price with Mr. Paxton?
I think we overlapped a year or two, and then he left.
After that time, how would you describe your relationship? Were you a friend or associate, or tell us in your own words, how would you describe your relationship at that time with Mr. Paxton?
We stayed friendly acquaintances. I saw him infrequently, but when I did, we always spoke. It was always pleasant. We had similar interests in politics.
And so then, how old were you, and where did you go from Strasburger Price?
Goodness. I left Strasburger and Price of January 2003, so I guess I was 48, 49. I'm not doing the math very well, but
That's
late,
okay.
late 40s.
And was Mr. Paxton, how long was he there? Did he leave before you?
Oh, he left many years before me.
After he left and you no longer remember the same firm, did y'all stay in touch?
Well, we had a mutual friend, and I would hear what he was doing, and I saw him infrequently, but we did see each other on a few occasions, and we went to the same church for a year or so.
Which church was that?
That was Stonebriar Community Church in Frisco.
After you left Strasburger Price, where did you go?
I spent a few months working in a small firm in Fort Worth, and then I got a job offer from the United States Attorney's Office in Dallas, which I accepted.
How long were you a federal prosecutor with the U.S. Attorney's Office in the Northern District of Texas?
For 16 years.
And what were your jobs during that period? And I want to try to do it if we can hit the high points.
All right. I started out doing general crimes, counterfeiting, identity theft, things like that. And after I'd been there a couple of years, I transferred to the national security section and worked on terrorism cases and export control cases for the rest of my time there.
And so the last 2 or 3 years, or 4 years even, what were your assignments as a federal prosecutor? How would you describe it?
I did some violent crimes, I did some computer crimes, but mainly I did terrorism cases. I helped out on a large mortgage fraud trial, and I worked on a very large export control matter involving a foreign company selling American technology to prohibited nations.
And how is it that you then joined the Attorney General's office? How did that come about?
I'd spent a year in D.C. at the Main Justice Department in the counterintelligence section in 2018, and in the summer of 2019, after I returned to Dallas, I got a phone call from First Assistant Jeff Mateer at the Office of Attorney General. He told me they had an opening for the Deputy for Criminal Justice, and he said Ken Paxton wanted me to interview for the job.
So he indicated to you the idea of giving you a call was Ken Paxton's?
Yes, sir.
Did you interview for the job?
I did.
Whom did you interview with?
Well, I came down here to Austin. I met a number of the deputies, met Lacey Mace. I met Lisa Tanner, who was the head of the Criminal Prosecutions Division. I met the Chief of Staff, Missy Carey, Ryan Bangert, several others. I can't recall everybody, but most of the people on the 8th floor.
And did you meet also with the Attorney General himself?
I did not meet with him in person. We spoke on the phone about a week later.
All right. And when you spoke on the phone, were you offered the job?
Yes.
So who offered you the job to come to work at the Attorney General's office?
Mr. Paxton.
And what year and month, if you recall, was that?
That would have been in July of 2019.
All right. Now, at some time until the end of the year of 2019, had you ever heard the name Nate Paul?
No.
And how is it that you ultimately did, if you did? Well, let me back up and ask. Did you ultimately become familiar with the name of Nate Paul?
Yes, sir.
And when was that you became aware of it?
On December 16, 2019.
And how and what was the occasion for you to become familiar with the name of Nate Paul?
I was in Dallas that weekend. Mr. Paxton called me, asked me to stay over on Monday and meet with him at the Highland Park Village Shopping Center at a coffee shop, and I agreed to do that, of course. And
Hold on. That'll get us to start. Now, when you got that call, explain to the jury how your working relationship, the agreement with as far as your residence in Dallas and working in Austin. What was your schedule by that time with the Attorney General's office?
Yes, sir. When I was offered the job, I explained to Mr. Paxton and to Jeff Mateer that my wife and I each had an elderly parent in their 90s in the Dallas area, and we were looking after them. And I couldn't move to Austin, but I could stay down here most of the time. And they said, look, just be here 3 or 4 days a week. We have a civil division office in Dallas. We'll give you a desk and a computer and a phone there. You can work from there 1 or 2 days a week. Typically, I worked in Dallas 1 work day a week, either a Friday or a Monday, and then commuted to Austin for the rest of the week, generally 4 days.
So that's why he asked you to stay over as opposed to come back to Austin?
Yes, sir.
All right. Did you meet with Mr. Paxton?
I did.
And the day and place that you met, you said Highland Park. The date was what?
It was Monday, December 16, 2019.
And where did you meet, and what was the circumstance for your meeting?
Well, first I met in the coffee shop. He was finishing another conversation. And then he said, let's go out to the car. We're going to make a phone call to a friend of mine.
So you went out to a car to have this phone call?
Yes, sir. And I don't remember if it was my car or his, but we had the phone call on his cell phone.
All right. And then I assume he put him on speaker?
He did.
And how did he describe, what did he say to you to describe who he wanted you to talk to?
He told me this was a friend of his who'd had some search warrants executed on his home and offices.
Did he say anything else before the phone call that you recall?
Not much.
All right. And then what happened?
Then Mr. Paul came on the phone. Ken Paxton introduced us. And then I listened as Mr. Paul told his story.
Objection, hearsay to anything he said.
Excuse me, did you listen in the presence of the Attorney General?
Sustained.
Excuse me, did you listen in, I'm sorry, I didn't mean to speak. Did you listen in the presence of the Attorney General?
Yes, sir. He was sitting at my right elbow.
And did the Attorney General also periodically make observations or discuss during a phone call?
Yes, he participated in the conversation.
I renew my questions, Your Honor. These are party admissions from the Attorney General himself. In fact, I wanted to go back to the original question and ask him what was said.
Go ahead.
Thank you. Now, can you recall what Mr. Paul said to you and the Attorney General in this car?
Mr. President, objection, hearsay.
I'm sorry? I didn't hear the apology.
Repeat your objection so he can hear.
I said it was objection, hearsay.
Sustained.
Your Honor, if I may, I certainly don't want to argue with the court, but this is a conversation that the Attorney General himself is participating in. And by participating and asking questions, he is really acceding to what the conversation is. And finally, the conversation in the presence of the Attorney General is not being offered for the truth of the matter. In fact, as the court knows, we contend that what he was saying is untrue. But whether that's true or untrue, we're not offering it to prove the truth, but only that that's what this witness was being told in the presence of the Attorney General by Mr. Paul. And so we renew our offer.
Mr. President, may I be heard in response? Mr. President, thank you. Nate Paul is not a party to this case. He's not an agent of any of the parties of this case. And party admission is not an exception to the hearsay rule, and none of the stated reasons to allow this information to come in are exceptions to the hearsay rule. So we renew our objection.
I have my legal counsel on some of these more sophisticated, complex issues. Former judge, of course, and will overrule this objection. Continue.
Thank you. You can answer that question. What did Mr. Paul say?
He narrated a series of events related to search warrants that were served on his home and 2 of his business properties in August of 2019.
How long did this conversation take place, would you estimate?
20 to 30 minutes.
Do you recall what your own thought processes were as you listened to him?
I thought, why is the Attorney General involved in this? Why is he wanting me to know about this? This is not a state matter, from what I could tell. And I thought it was very suspicious that someone who was the target of a federal investigation was reaching out to the Attorney General of Texas for legal help.
Did you make sure in your conversation with him in the presence of the Attorney General to Mr. Paul that you yourself were not allowed or able to give him legal advice?
Yes, sir. I specifically told Mr. Paul that. I said, I represent the state of Texas. I can't be your lawyer. I can't give you legal advice. Do you have counsel? And he gave an affirmative answer. And I said, you need to talk to your counsel about this so they can guide you.
All right. When this conversation was over, and I think you said it was like 20 to 25 minutes.
Yes, sir.
Did you talk to the Attorney General about that subject anymore? On that occasion?
Yes, sir, we did, and on later occasions. But on that day, December 16th, he made comments to me that indicated he was very mistrustful of law enforcement, and he made a comment as to how he felt about how he'd been treated by law enforcement, which was in a negative way.
Do you recall what he said, please?
He said, I've been the subject of a corrupt investigation.
Did you know at that time that he had pending criminal charges?
I knew about the securities fraud charges. I knew nothing about the facts of the case, and I still don't.
Okay. Now, at the end of the day, on that occasion, did he say any more to you about his feelings about law enforcement in general?
Not on that day.
All right. Then after that occasion, when is the next time that you heard anything about Nate Paul?
It was on June 16th or 18th of 2020.
Let me stop you there. So is it your testimony that from that conversation in December of 19 until June of 2020, you neither heard nor had any involvement with any issues involving Nate Paul?
That's correct.
All right. And then what was the date in June, did you say?
It was either June the 16th or the 18th, to the best of my recollection, because those were the dates of our 2 weekly staff meetings.
All right. So that the jury knows, there's been some reference maybe to different meetings. What was the normal schedule about staff meetings of the upper management of the AG's office at that time when you were there in 2020 and 20?
We met every Tuesday and Thursday. If the Attorney General was in town, he attended, but First Assistant Jeff Mateer chaired the meetings if he wasn't there. And if I'm correct, on one of those days, we had a strategy meeting.
Hold on. I'll get there. I didn't ask you about that yet. On those meetings, how long would they last, and what time of day would they usually be?
I believe they started at 9 or 9:30, and they would last an hour and 15 minutes.
Where would you have them?
In the executive conference room right next to the Attorney General's office on the 8th floor.
And who all, and to do this slowly so the jury can absorb who all in the upper staff would be at these weekly meetings. Who all would attend those weekly meetings?
All of the deputies, and there were 12 or 13 positions at the deputy level, the first assistant, and if he was in town, the Attorney General.
All right. And what about the chief of staff? Would she attend the meetings?
Yes.
And who was the chief of staff at that time?
That was Missy Carey.
All right. Would there be any other staff member? And let me ask you this. Were you familiar with the young man named Andrew Wicker?
Yes, sir.
And what was his position?
He was a personal assistant to General Paxton. He had a desk outside his office, and he traveled with the general and just took care of whatever duties the Attorney General gave him.
Would Mr. Wicker ever attend any of these meetings?
I don't have a specific recollection of that one way or the other.
All right.
And if I may, sometimes other staff people and other executives were present. So I'm not trying to say it was only the deputies that were there. There could be different people involved on different days.
So would Mr. Wicker perhaps attend sometime at the request of somebody?
Certainly you could.
All right. Now, back to the June time when you say that you became familiar with the name of Mr. Paul. What was the circumstance in which you again came into contact with something about him?
It was the weekly deputies meeting, and I believe it was on a Thursday. The Attorney General was present, and he announced that he had received a referral from the Travis County District Attorney's Office. And after the meeting was over, Jeff Mateer handed that referral document to me and David Maxwell.
All right. So at that meeting, was that a meeting just between you and Mr. Maxwell and Mr. Mateer?
Well, initially it was the deputies meeting with everybody present, but then as the meeting adjourned, Jeff Mateer asked me and Mr. Maxwell to stay, and we talked about the referral.
All right. Once you became aware of the referral, what did you do?
Well, first I read the referral and realized I've heard this story before.
And was the referral, and why did you say that you had heard it before? What was it about the referral that was similar to what you had heard before?
Well, it was basically the same story in a little more detail, and it was typed up. It was unsworn, but it was signed by Nate Paul.
And did you learn where that complaint had originally gone to?
Yes,
The answer, that's good enough.
All right, sir.
Thank you. And then, did you, when you read the referral, did that inform you as to how it originated and with what agency?
Yes, sir.
And which agency was that?
That had initially gone to the Travis County District Attorney's Office.
Were you informed at that time by the Attorney General, one way or the other, anything about whether he had already personally met with representatives of the District Attorney's Office about this matter?
Not that day, no.
All right. So did you share that referral and what it said with Mr. Maxwell at that time?
Well, we both read it.
All right. And then did you lay out a plan of action as it applied to that referral?
Yes, sir.
Did you at that time, what did you do after that meeting and you had been shown the referral?
Well, the first thing we did was talk about it, the three of us. And
And
David,
when you say the three of us, you mean who?
Jeff Mateer, David Maxwell, and me.
After you had that conversation, did you make any plans for how you would deal with it?
Yes.
When did you make plans? Your initial reaction, what did you do with it?
Well, my initial reaction was, this is crazy.
All right. After you, and without going into anything Mr. Maxwell said, what type of reaction did you get from him when he read it?
The same as mine.
So then did you decide not to investigate it at that time?
We hoped to slow walk it and see if the Attorney General would drop it.
All right. Did you talk to the Attorney General any more about it before you then met with anybody about it?
I think the Attorney General talked to me.
And when did the Attorney General talk to you after he had informed you of that referral?
I recollect two conversations. One of them occurred in my office when he came to my office.
All right, let me stop you there. I want to know when that was. How soon did you have a conversation with the Attorney General about that referral after you were after it was given to you on the morning of the 16th?
The first date I recall was July the 6th of 2020.
Well, from the time you got it on June 16th to July the what?
6.
Had you done anything with it?
Only talked to David Maxwell about it.
All right. What was the occasion for the Attorney General coming to talk to you about it on July the 6th?
He just knocked on my door and walked in and wanted to talk about the status of the Nate Paul referral.
Do you recall what he said?
He was unhappy that nothing was happening. He said he wanted us to get moving on it. That was basically the gist of the conversation.
Well, why was it that nothing had happened on it from June 16th to July 6th? Did I get that date wrong? Was it July 6th or July? Yeah.
There was one conversation on July 6th.
All right.
And there was another one.
All right. Why had nothing happened between the 16th or the 6th, or had something happened?
David Maxwell and I saw no merit to the complaint. We saw no state interest. We saw no evidence of a state crime violation.
So what did you do when he came in and talked to you on the 6th? What was your response?
I told him I'd talk to David Maxwell and we'd get moving and set up a meeting with Mr. Paul and his attorney at some point.
Were you opposed to having that meeting?
I wasn't opposed to having a meeting, no.
All right. Well, why haven't you arranged it before then?
Again, speaking for myself, I thought it was crazy, and I was hoping the Attorney General would drop it. He didn't.
Why did you think it was crazy?
The idea that the state of Texas Attorney General's office would go investigate the federal courthouse, investigate federal agents, and also state agents that were task force officers on the raid, and those were agents from the DPS and the State Securities Board, that we would investigate a federal magistrate judge and federal prosecutors was insane. That is something that can be handled by federal authorities, and there's no easier practical way for state authorities to investigate the type of complaints Mr. Paul was making.
Why? What was it about the complaints that would have been difficult or so for you to investigate?
Well, as the matter developed, their main complaint that could theoretically have been a state criminal violation was that the Assistant United States Attorney who got the search warrants signed by the magistrate judge had then altered the warrant after it had been signed by a federal judge, which was absolute craziness.
All right. Why is that craziness?
Because that would be a felony, that would get you fired, that would get you sent to federal prison.
All right. So why was that crazy? People commit felonies all the time.
They do. I knew the assistant U.S. attorney. He used to work in Dallas. He had a stellar reputation. He had very high personal integrity. I'd never seen any indication in Dallas that he would even think of doing such an outrageous thing.
Well, let me ask you this. Was it just limited to a complaint about federal officials?
Well, there were state agents involved in the searches, and Mr. Paul, at a later date, named one of the state agents as being the affiant on the sealed federal search warrant affidavit.
All right, I was going to ask you about that. First of all, were there agents from this Texas Security Board involved in the search warrant? Were there?
Yes, sir, there was at least one.
And were those security folks, the security board, the same agency that had brought charges against the Attorney General and that were part of the case that was currently pending against him at the time he wanted you to meet with Mr. Paul?
Objection, leading, Mr. President.
Sustained.
Were there, could you tell us, at your observation at the time, whether actually the Attorney General was asking you to investigate a matter with Mr. Paul, who was being, he was, let me put it this way. Were you aware, or did you focus on the fact that one of the things one of the groups that they were asking you to investigate was the very agency that had brought the charges that were currently pending against Mr. Paxton?
Objection,
Yes, sir.
leading, Mr. President.
I believe he had a choice there. He could have said,
Overruled.
Thank you, Your Honor. All right. So was that also did that give you any concern?
Yes, it did.
All right. Into the microphone. What was that concern?
Well, my concern was not only was he asking us to investigate state agencies, including an agency that was investigating him, but he was asking us to investigate the investigators who were conducting a federal investigation of Nate Paul.
All right. Now, once he asked you to do something to get moving on it, what did you do?
I told him I'd talk to Mr. Maxwell and we would get moving.
Did you do so?
I did. I talked to Mr. Maxwell.
I don't want you to tell us what you told him, but after you talked to Mr. Maxwell, what was the next course of action?
Well, we had a brief delay. Mr. Maxwell was out of the office for a few days. And after that, the Attorney General spoke to me again on July 16th. But eventually, we did schedule a meeting for Mr. Maxwell to meet with Mr. Paul and his attorney, Michael Wynn.
All right, hold on a second. You said you had another conversation with the Attorney General before you made your first meeting with Mr. Paul. Is that correct?
That's correct.
What was that conversation, and when was it?
That was on July 16th, and that was in a little more detail. He told me that
Wait, stop. Let's set the stage for it. Where was it and about what time of day?
I don't remember if that was in person or by phone.
All right. What did he tell you?
He told me that he wanted to get things moving. He said there'd been a leak to Texas Monthly about issues surrounding the federal raid, and I never saw the story, so I don't know the specifics, but he was concerned that something had gotten out in the press. And then he mentioned that Mr. Paul's sister was his personal counsel. I never spoke to her, but again, he was insisting that we get moving and do something with the referral.
Mr. President, just briefly, can we have the witness clarify for the record that Nate Paul's sister is, Sheena Paul is Nate Paul's personal counsel and not the Attorney General's?
Certainly, I have no objection to that.
Would you clarify that, please?
Yes, sir. He was saying that Sheena Paul was Nate Paul's personal counsel.
Thank you, Mr. Penley.
All right. Now, so then when was the meeting with Mr. Paul?
The first meeting was on July 21st.
And who was at that first meeting?
That was conducted by David Maxwell on behalf of the OAG. Nate Paul attended along with his personal counsel, Michael Wynn.
Michael Wynn is spelled, do you know how, for the court reporter?
It has an E on the end, W-Y-N-N-E.
Thank you. Now, were you present or watching this interview or anything?
I didn't watch it live, I didn't attend it, but I watched it later. It was video and audio recorded.
Do you recall about how long that lasted?
It was over an hour, maybe an hour and 15, 20 minutes.
Okay. May I have the exhibit number? Your Honor, may I visit the table just for a second? When did you view the video?
I viewed it on July 23rd.
Were you aware of any meetings, without going into what anybody told you, were you aware of any meetings that the Attorney General had with other members of the executive staff about Mr. Paul just the day before, on July 22nd?
No, sir.
All right. So when you met, how is it that you reviewed the interview? The date of the interview was what?
July 23rd.
And then when's the next time you heard from Mr. Paxton about that matter?
Mr. Paxton called me on July 23rd and said he wanted me to come to his office and view the video with him.
Did you do so?
I did.
So, had he ever asked you on any occasion to look at evidence or so, or interviews or so, that meetings or so, that you were dealing with on criminal justice matters?
Not as a general matter. There are two exceptions.
What are they?
There was one case up in the Panhandle where someone in a town met him at a political event and asked him for our office to take a look at a cold case.
All right. Did your office do that?
We did.
All right. And then what's the other occasion?
There was an occasion in July of 2020 where a former deputy at the Attorney General's office, who was in private practice in San Antonio, represented some parents in a drowning case, and he contacted the Attorney General and wanted our office to look at this drowning case down there where Bayer County was not pursuing criminal charges.
All right. Now, those are two occasions that previously, excuse me, that previously during your service he had asked you to look at, correct?
Yes, sir.
Now, would you describe the level of involvement that he had in each of those cases compared to the involvement he had with Mr. Paul?
Vastly different.
How? Now, I don't want to really go into the facts of the other two cases.
Right.
I just want to know, I want to ask you to describe in each of those two other occasions that he had contacted you on behalf of some constituent. Describe what his behavior, what his involvement was in those cases.
Yes, sir. On the Panhandle case, he asked me to look at it. Our law enforcement division had looked at it. I reviewed what they had done. I reported to him that they had done everything that could be done, and he accepted that and didn't bring it up anymore.
What about the Bexar County case?
On the Bexar County case, I made some phone calls. I looked at some evidence the family's attorney had sent me. I made a report back to the Attorney General that I didn't see any state criminal charges that we should pursue. He accepted that and never brought it up again.
In either of those cases, did he have any further involvement after asking you to look at it?
No, sir, other than asking me to report back to him.
And after you reported back to him, did he have any further involvement in either of those two cases that you're aware of?
Not to my knowledge. He didn't with me.
By the time July 22nd rolls around, July 23rd rolls around, how many times had the Attorney General talked to you about the Nate Paul case? Just take your time and count back up to that moment.
I'll count 3 to that moment. Well, actually 5 to that moment, counting the December phone call.
All right. Now, when you describe for the jury how this review of the video of the initial interview by Mr. Maxwell of Mr. Paul with his attorney present.
We watched the video together. Mr. Paxton was unhappy with David Maxwell because David Maxwell was not accepting what they were saying at 100% face value.
Well, let me ask you this. Did you see anything as an experienced law enforcement professional that was objectionable about the way Mr. Maxwell was conducting the interview?
No, sir.
Your Honor, at this time, it's already in, but for the record, I'll say that Exhibit 149 is a video and audio. I'm not going to go into it right now, but it is a video and audio of the initial David Maxwell interview, if the jury later decides they want to look at it.
All right, thank you.
149. Now, after you looked at that interview, do you recall anything else that the Attorney General said about it during the course of watching it with you or after it was completed?
He made comments that told me he didn't understand the significance of some of the claims they were making. Number one, he didn't recognize the legal difficulties for us to investigate the federal authorities when a search warrant is under seal at the federal courthouse. I didn't see any way we could get that realistically other than by asking the federal judge if he would open up the sealed record and let us examine the issued search warrant and compare it to the returned search warrant.
All right. So now at the heart of this thing that you've looked into the file, there's been one interview, you've heard from Mr. Paul. Let me back up. In that interview you watched, who does most of the talking in the interview?
Nate Paul.
Does his lawyer also participate some in it?
He does.
And in the case of, how much does Mr. Maxwell talk in there, if you could just characterize it?
I'd say Mr. Maxwell spoke 35 to 40% of the time. He asked questions, appropriate questions, and then they gave answers.
Did you find anything objectionable about the questions or the way Mr. Maxwell was asking them?
No, sir. In fact, he made some very excellent comments to them about where they should go to get relief.
All right. In that particular document, Mr. Maxwell is suggesting they go where for that complaint they had?
He told them the best place for them to go to get help with their complaints was the Department of Justice Inspector General's office, because that office would have the power to investigate federal authorities.
Now, let me ask you something that may perhaps not have been clear in this trial at all. If a search warrant is run in the federal court where you were for a number of years, and ultimately a judge has signed it, the warrant is executed, evidence is gathered, and then ultimately charges are filed, and the person, something happens with them, or they're indicted, if they have a pending criminal case, what is your experience as to whether the defendant that would then be given access to not just the search warrant, but the probable cause affidavit?
Objection, Mr. President, leading and calls for speculation.
I'm simply asking what's his experience if that's...
Overruled.
Thank you.
Well, the way it works is the assistant U.S. attorney and the agent go see the federal magistrate judge to ask for a search warrant to be signed, to be approved. And when you go, either beforehand or at the time you're talking to the judge, the agent presents a probable cause affidavit, which lays out the key facts of their investigation, which the AUSA and the agent believe established probable cause to get the search warrant under Rule 41.
Now, let me stop there. At that time, in the affidavit they present to the judge, does it describe what all kind of information would be in there
Yes.
that they might later ask be sealed?
Yes, there's often confidential law enforcement evidence in there. There is information. If there's an informant in the case, that information may be in there. The work the agent has done to that point, the investigative steps they've taken, what they've uncovered, the facts they've developed are laid out so that the judge will see probable cause exists. And if the judge rejects it, you don't get the warrant.
All right. And in addition to what you just described, is there information in there potentially of other citizens who may have talked to the government and provided information?
Yes, sir, and other confidential information.
So if in fact the magistrate or the judge signs the search warrant and it is executed, what happens then in terms of the warrant being given and the affidavit being given? What is the practice?
Well, the original documents are given to the judge's clerk, who files them under seal in the federal district clerk's office. Now, typically there's a motion to seal filed by the assistant United States attorney. If that's granted by the judge, and they routinely are, the clerk's office keeps that under seal. So they're not going to give it to anybody except the court or the government. A target of an investigation is not entitled to see the affidavit, which lays out the facts of the investigation, until they've actually been indicted and are entitled to discovery.
So if their charges are filed against them and they're indicted, then what is the law, what is the practice as to whether they then get the probable cause affidavit?
At some point, that would be unsealed, and the assistant U.S. attorney would send a copy of the previously sealed search warrant affidavit to the defense attorney.
But if they are not charged as yet, and not charged at that time, or not charged immediately after, what will happen with the sealed probable cause affidavit, and whether or not that target that you've used the word is entitled to see it until charges are filed?
The target is not entitled to see it until charges are filed. And sometimes charges aren't filed, but they don't get to see it. That's confidential law enforcement investigative material. It's very important that not leak out, because the target could go destroy evidence. He could go intimidate witnesses and do other things to undermine an investigation.
In the case, did you relay essentially the kind of information you just told the jury to the Attorney General?
At various points during this entire matter, yes, I did.
All right. And at some time, did you express to him the fact that you would not have access, even you yourself in the Attorney General's office, would not have access to that sealed probable cause affidavit?
Yes.
Now, if in fact somebody made a public information request, would what was in the sealed affidavit be potentially provided by the law enforcement authorities for them to decide whether to release it or not?
Objection, Mr. President, calls for speculation on the part of this witness.
I'll ask this, if it's okay.
Abstain.
Thank you.
Rephrase.
Thank you very much. Do you have any personal knowledge of how the public information request would work for somebody who wants to see a probable cause affidavit that he has not been given by the federal judge?
Yes, I have an understanding that there is a law enforcement exception in the public information request laws, and that an agency has a right, when there's a pending law enforcement investigation, to keep that private and not release it to a requester.
So in order for the Attorney General's office to know what their position to be and whether the law enforcement exception applies, would the agency that is seeking to withhold the information reveal what is in the probable cause affidavit in order for the Attorney General's office to make the decision?
Objection, leave.
If you know.
My understanding is,
Hold on, Mr. Penley.
Sustained.
Thank you.
All right. Now, let's move on if we can. After you had that meeting with the Attorney General, and when you two of you watched the movie, I think you said on July 23rd, what was the next thing you did that was in connection with Mr. Paul's case?
on July 28th or 29th, I received a phone call from Mr. Wynn requesting a second meeting, which I agreed to.
All right. Now, at this meeting, when did that meeting occur that the lawyer for Mr. Paul requested? By the way, why did you give him another meeting?
Why did we need another meeting?
Yeah.
Well, I hadn't attended the first one. He was asking for it. I was trying to show the Attorney General we were being accommodating and willing to listen to whatever they had. So I agreed to a second meeting, which we scheduled for August the 5th.
All right. Did you do anything in connection, in preparation for that meeting on August the 5th, the second meeting on Mr. Paul?
Well, I had reviewed the entire transcript from the first meeting, and I'm sure I had spoken to Director Maxwell.
All right. And then what happened on the next meeting? And again, what date was it, the second meeting?
August the 5th.
What happened at that meeting?
That meeting was also in the law enforcement interview room, so it was audio and video recorded. Mr. Paul and Mr. Wynn came. They had not brought any documents to the first meeting, which surprised me, because normally when a complainant comes in, you expect them to bring their evidence. But this time they brought documents because I had asked Mr. Wynn to do that during our phone call on the 28th or 29th.
All right, Your Honor, if I may, just for the record, that interview is Exhibit 156 that is in evidence, and I'm not going to ask at this time it be played. It's a long interview, but it is available during deliberations for the jury to review if they choose to.
Thank you.
Now, in this second meeting, about how long do you estimate that lasted?
About an hour and a half.
Were there just 4 people there?
Yes.
And that meeting, how did that conclude?
Well, it concluded that I told them,
Stay back with the microphone.
thank you for coming in. We've heard your theories. They had really stressed that their proof of alteration of a federal search warrant was in the metadata of those documents. So I told them that we're going to get with our computer forensic examiners that work for Director Maxwell. We'll review this with them. We'll explain your theory, and I'll get back to you.
All right, so now what was the contention that they were saying that would show that, well, let me back up. Were they talking to you in terms of warrant is presented, judge signs it, and then supposedly the law enforcement people changed to that affidavit?
Yes, sir.
And what was, as you understood it, the contention as to why it was changed?
Their contention was that
Microphone.
the magistrate judge had signed it on August the 12th, and they claimed that they had metadata from the documents that showed it had been changed on August the 14th, the day of the first searches. And they claimed that, their theory anyway, which again sounded insane to me, that initially the search warrant had been approved to search for guns and drugs and related items. But after the agents got there and started the search at 9 o'clock, by 11 o'clock, the Assistant United States Attorney was changing the search warrant to a white-collar crime type of search warrant, seeking documents and computer files, bank statements, financial records, things of that nature. And that was insane.
All right, so did they have any reason they would not have gone back to a federal judge and said, hey, these guys changed your warrant?
I asked
Action, Mr. President, leading.
Well,
Sustained.
let me put it this way. What was the reason that they would not go back to a federal judge to complain, these guys changed your warrant?
Right.
Objection, Mr. President. Speculation as to what someone else thought.
Your Honor,
Sustained.
excuse me. Did they give you reasons as to why they wouldn't go back to federal judge?
They told me they had done that, and I inquired further.
When did they say they'd gone back to him?
They told me they actually had a hearing in late February of 2020 because I asked Mr. Wynn, who's a former assistant United States attorney in Houston and Austin and a graduate of Harvard Law School, why are you coming here? Why don't you go file a motion with the magistrate here in Austin who signed the warrant? He's got the power to deal with everything.
And so instead of doing that, did they then contend the federal magistrate was in on all this?
At some point they
And
did.
Mr. President, leading.
Sustained.
Then why would they not go back to the federal magistrate or to the federal district judge? I think everybody in the jury may know this, but just to be sure, the search warrant was entered by a federal magistrate, correct?
Correct.
And that federal magistrate handled matters like that on behalf of a federal district judge, correct?
Correct.
Did they have any explanation as to why they hadn't gone to a federal district judge to complain about this magistrate who must be in on this whole thing?
No, and in fact, that was one of the giant red flags that was raised in my mind by that
Back to
meeting.
the microphone, please.
And the
Microphone, please.
Mr. President, I'm going to object as non-responsive to everything after no. It's a yes/no question.
Sustained.
All right. Now, please remember the microphone
Yes, sir.
to make sure people in the back can get it, all right? Now, at the end of the day, what is it that they wanted you to do?
They wanted us to agree with them on their metadata theory and agree that an assistant United States attorney had illegally, at a felony level crime, altered search warrants after they were issued by a federal judge, and that 2 assistant United States attorneys, a federal judge, and a whole bunch of state and federal agents were in on a grand conspiracy to cover this up and target Nate Paul.
So did they want you to investigate all of these people that you've just elicited?
That was my understanding.
Yeah. Well, now, when the meeting was over, what did you do?
I talked to Director Maxwell. He took the thumb drive. I said, we both discussed the fact that his computer forensic examiners needed to analyze the documents based on their contention that the metadata would show an illegal alteration.
And what would you need to be able to show an illegal alteration that addressed the issue as to whether it had been illegally altered or not?
You would need the actual computer that the assistant United States attorney used to type up the search warrant documents, and you would need his computer files, the original computer files, which only existed at the United States Attorney's Office and would be subject to all kinds of privileges.
Well, let me ask you this, though. If the search warrant is signed by the magistrate and is taken out and executed, right? And then ultimately a copy of that search warrant is given to the lawyers of the target. Are you with me?
Yes, sir.
What documents could you potentially compare to see if the original search warrant was altered? What would you need?
Objection. Calls for speculation, Mr. President.
No, this is what...
Overruled.
Thank you.
The source material, the Rosetta Stone, if you will, would be the sealed search warrant that was actually signed by the federal magistrate and on the day of signing was placed under seal at the federal district clerk's office. So if I had the original issued search warrant and I got the return search warrants that were actually served on the defendant, not the affidavit, but just the warrants themselves, and you could put those together and you could see if there were any changes in the original and in the copies that were given to the defendant and the copies that the agents filed back with the clerk's office after the search is concluded. The agents fill out an inventory of all the items that are seized during the search, and they file that back with the district clerk's office, and it goes in the file together. So if I had the beginning and the ending, I'd have a bookend.
All right. And were those documents the ones that were under seal?
The originals, the issued sets were under seal, and I had no access to them.
All right. So without going into what your experts told you, did you have these materials, or what you had, at least the original warrant, did you have your IT people look at it?
Yes, in the thumb drive that Mr. Paul and Mr. Wynn gave us on August the 5th.
President, I need to object again as non-responsive after
That's
the
fine.
question.
That's fine. We'll do it real quickly. Did
Sustained.
you, excuse me, thank you. Did you in fact give the information they gave you to your IT people to look at?
Yes, sir.
Without going into what they said to you, did they come back to you with a recommendation?
They gave us their opinion, yes.
Were they able to find anything that would determine one way or the other with the information they had available?
Objection, hearsay.
Whether they could find? How is that hearsay? I'm sorry. I'm learning a lot in this case.
Overruled.
Thank you.
The metadata theory advanced by Mr. Paul and Mr. Wynn was not validated.
And so were you able to tell from your experts one way or the other as to whether there had been any alteration?
The only alterations were through innocent functions.
What do you mean?
If you redact anything in a search warrant, which is routinely done, that
Let me
will...
stop you. The kind of things that might be redacted would be what?
If there were other targets in the investigation that were listed in the warrant, in one of the attachments, routinely you redact the name of the other target.
All right. And so if there are redactions, what happens?
That will change the metadata.
All right. So ultimately, were the experts in your office able to answer one way or the other whether or not it had been redacted?
Yes, they were able to tell it was redacted. We had copies of the warrants, and it showed redactions.
All right. Were they able to offer an opinion as to whether or not that meant the document was changed for the basic things that were contended by Mr. Tall's lawyers?
Well, let me explain it this way.
Let's do it shortly. Let's see how you do.
All right. There are innocent functions that can change metadata that are routinely done. I had evidence those innocent functions were done. Therefore, the metadata theory proved no wrongdoing. It proved no criminal conduct by the federal authorities. There was no evidence of a crime.
All right. And then what did you do after you got this report back from your people?
That was on August the 6th. A couple of days later, I saw the Attorney General in the hallway, and I said, Ken, there's no evidence of a crime. I recommend we close this investigation.
All right. And what was his response?
His response was, okay, fine. All I ask you to do is meet with them and tell them, which I agreed to do.
All right. So what happened then?
I scheduled a meeting. I called Mr. Michael Wynn. We set up a meeting for August the 12th, which I believe was a Wednesday, again here in Austin. And a couple of days after that, this was before the August 12th meeting, I saw the Attorney General in the break room, and I told him I'd set up the meeting as he requested.
All right. Then what happened?
Well, he told me he wanted to attend. So I changed the meeting location to the executive conference room so it'd be right next to his office for his convenience.
Now, was this meeting either videotaped or audio taped?
No, sir, there was no video or audio in the executive conference room.
All right.
Not for recording a meeting.
Excuse me. So when did this third meeting with Nate Paul, did Nate Paul attend the third meeting?
Yes, sir.
So when did this third meeting with Mr. Paul and his attorney occur, and who all was there?
It occurred on August the 12th in the morning. The Attorney General attended. I was there. Director David Maxwell was there. His two forensic examiners that we had met with on August the 6th were there. Drew Wicker, the Attorney General's assistant, attended, and Mr. Paul and his attorney, Michael Wynn, were there.
And during this meeting, did the Attorney General stay? How much of that meeting did he stay for?
He stayed for about 3/4 of it.
All right. So what happened in this meeting?
Well, I opened the meeting and announced to Mr. Paul and Mr. Wynn that I thanked them for coming and said, we've looked at your metadata theory, but we don't find any evidence of a state crime, and we're going to close our investigation.
What was their reaction?
It was very unhappy. They pushed back immediately.
How about Mr. Paul? How would you describe his conduct?
He was angry.
So as both of being angry, what did he do?
Well, number one, the Attorney General was also unhappy, and then Mr. Paul demanded that a laptop computer be brought in because we had discussed what the forensic examiners had told me and Director Maxwell. He disagreed with them, demanded a laptop be brought in, so the Attorney General told Mr. Wicker, go get your laptop and bring it in and hook it up. There's a video screen at the end of the room.
Did Mr. Wicker do that?
He did.
And then what did Mr. Paul do?
He got on the keyboard, he pulled up a document, and he said, what I've just shown you here disproves what your forensic examiners are saying.
Did it?
I'm not a computer expert, but I know that the forensic examiners didn't tell me they were wrong.
Yeah. And I'm curious, how was Mr. Paul acting in this meeting in terms of who was in charge and what was going to happen here?
Mr. Paul acted like we didn't understand who the real boss was. It wasn't the Attorney General, it was him. That was his body language, that was the expression on his face, the way he bowed up. He got very unhappy with us. He got very unhappy when Director Maxwell called him out for leaking our investigation to the media.
Let me stop there. What are you talking about there?
There were two publications that printed reports about Nate Paul and some of his civil litigation issues and bankruptcies, and they reported quotes.
Objection, hearsay.
All right. He doesn't want you to report
Sustained.
about. Thank you, Your Honor. He doesn't want you to talk about what the articles were.
Right.
So my question is, what did Mr. Maxwell say to him in the presence of the Attorney General?
He said, you leaked the fact of our investigation to the media.
All right. And what was the import of that? Why was that a concern?
When you're doing a law enforcement investigation, you don't do it through the media. You keep it confidential. You don't want to alert the target. You don't want people destroying evidence or hiding evidence. You keep it quiet. And secondly, sometimes the targets of your investigation may not have done anything wrong. You don't want to smear people's reputation unnecessarily due to the fact that they've been investigated.
What was Mr. Paul's reaction to that?
Mr. Paul pushed back against Mr. Maxwell and said he had a First Amendment right to talk to whoever he wanted to.
And he didn't deny that he'd done it, did he?
Initially he did, and then he admitted it, which told me something about his veracity.
And then what was the Attorney General's reaction?
The Attorney General took his side and agreed with him that he had a First Amendment right to talk.
So then what happened?
Shortly thereafter, the Attorney General announced he had to leave, and a few minutes later, the meeting was not productive anymore. Mr. Paul and Mr. Wynn were unhappy, so I closed the meeting.
Again, this meeting was on what date?
August the 12th.
And then what happened after that?
The next day, we had our weekly deputies meeting on Thursday. Jeff Mateer was there. I met with Jeff after the meeting.
I'm confused. Earlier, you talked about a weekly deputies meeting on Tuesday.
I believe, and I'm trying to remember this, I could be wrong, but I think the deputies meeting was on Thursday, and I think we had a policy and strategy meeting on Tuesday. If I'm mistaken, then reverse it.
All right, but are they the same people attending?
There could be differences. The policy meeting might be a smaller group.
All right. So what was this meeting that you had on Thursday after the previous meeting?
After our regular weekly staff meeting on Thursday, David Maxwell and I stayed behind, and we met Jeff Mateer either in his office or in the executive conference room, just the three of us.
Without going into what was said at that time, did you become ultimately aware of anything having to do with an outside counsel being hired?
Not at that time, but later I did.
All right. And then when did you first become aware that the Attorney General was considering or wanted to hire an outside counsel to investigate Mr. Paul's complaint?
Well, number one.
But by the way, let me stop. You mentioned something about this a moment ago. When you're investigating people and wanting to find out information, and so in your years in law enforcement, do you put people that you want to elicit information from under oath?
No, sir.
Have you ever done that?
Rarely. Sometimes in federal practice, we would bring somebody into the grand jury, but that was not a common practice.
Well, let me ask you this. Have you ever put people that you were trying to investigate or get information from in an investigation, other than presenting them in a grand jury and where they're sworn in, do you ever swear in people that you are trying to get information from, that you want to sit and talk to you, inform you?
Objection, relevance, Mr. President.
Very relevant. I think we've had this allegation has been made repeatedly by these guys.
Overruled.
Thank you.
No, sir.
All right. Are you familiar with anybody in law enforcement doing that?
I don't believe that's a routine practice, no.
Well, as a matter of fact, the complaint that Mr. Paul went down and filled out that started all this with the Travis County District Attorney's Office. Have you looked at that complaint form?
I have. I've read it.
And on that complaint form, does it have a place to have the statement and complaint notarized, therefore being sworn under oath?
It has a place, yes.
And the complaint filed by Mr. Paul in that matter, which is called, we'll call it referral number 1, did he swear to that complaint that he was making all these allegations?
No.
And then there's another referral. Did you become aware later of another referral?
I did.
By Mr. Paul about another group of people he wanted investigated?
Yes, and that was also to the Travis County DA's office.
And again, is there a place there for it to be notarized so he could swear under oath?
Yes.
On the complaint?
Yes.
Did he do so?
No.
So the 2 complaints that he wanted you to investigate, with all of these allegations about all these people, did he swear under oath to a single one of those allegations?
No, sir.
If he had, would that potentially, and if they were untrue, would that potentially subject him to a charge of perjury?
I believe so.
So if he doesn't swear to it under oath, does it potentially open him up to perjury?
No.
All right. Now let's go to, after you have this meeting about outside counsel, when do you become aware, if you do at all, of the possible people that are being considered by the Attorney General to be the outside counsel?
After the August 12th meeting, the Attorney General did not talk to me about the Paul matter for a number of weeks. I believe...
All right, just keep your voice up. I steal the microphone. When you pull back, both of us, when we pull back, we get away. So again, keep him up. Would you tend it just a little bit?
Turn it down. Is that better?
Thank you. That is better.
All right.
Go ahead.
I can't move the base, so I'm just trying to stretch it out.
All right. So when you leave that meeting after we talked about that the Attorney General was there for most of it, when is the next time that you did anything in relation to this particular matter with Nate Paul?
The next thing I recall hearing was on September the 3rd when I had been making phone calls to Michael Wynn trying to get additional documents. I wrote a note to the Attorney General on August 13th, the day after the meeting, and I told him I'd re-examined the copies of documents Mr. Paul and Mr. Wynn had given me, and I realized it didn't appear they'd given me all the evidence they told us they had. So I started making phone calls to Mr. Wynn, and I told the Attorney General in my August 13 note there might be further steps I could take if they'd give me all the documents.
All right. So if anybody was to suggest that you had refused to investigate or do anything else on this case, would that be an accurate or inaccurate statement?
Objection, Your Honor, assumes facts not in evidence.
Sustained.
I'm sorry, I was trying to think if that was actually something that wasn't in evidence. Pardon me. Let me ask you this. Would it be an accurate statement today to say, one way or the other, as to whether you had refused to investigate this matter?
I did not refuse, and I did investigate this matter, and I continued after August the 12th to attempt to investigate it.
And in attempting to investigate it, how did you go about attempting to?
I told the Attorney General I needed all the documents Mr. Paul had, and I made numerous attempts to contact Mr. Wynn and request all the evidence they'd been given by the magistrate judge at that February 2020 hearing.
Had he ever provided that to you?
No, sir. He never provided me any further documents after giving us the thumb drive on August the 5th.
Did he ever address whether or not the hearing before the magistrate had been on the record back in February of 2020?
He did not. I believe he told me it was not on the record, but I'm not absolutely certain.
Do you know one way or the other as to whether it was on the record?
I don't have personal knowledge.
Did he attempt to provide you any information of anything the magistrate said at that hearing?
He told me a few comments that had been made, and he told me the judge gave him some documents that afternoon, and that's all he said.
Did you ask him to provide you those documents?
I did ask him to provide me those documents.
Did he?
No.
All right. How many times would you think after the meeting in the Attorney General's office that you described, the third meeting, how many times would you estimate you reached out to Mr. Wynn in an attempt to get further documents?
5 to 6 to 7 times.
And were you successful?
No, I never got a single piece of paper or another thumb drive or anything.
Do some of those times you reached out, are they voicemails that you left for Mr. Wynn?
Yes, some were voicemails.
How many times were you able to talk to him actually after the meeting in the Attorney General's office seeking additional information?
The only record I have of reaching him is one time, and that was on September 14. We had a 5-minute phone call.
All right. And that 5-minute phone call, were you promised documents?
No, I wasn't promised documents, but I was promised he was going to talk to Mr. Paul that afternoon and that he would get back to me by the end of the day, and he never did.
All right. So did you ever hear from him again about those documents?
No, sir.
All right. Now, what impact did that inability to get documents from have on you?
It affected my thought process in a major way.
Your microphone, please.
Number one, when you're doing a criminal investigation and you have a complaining witness telling you a story, you have to believe they're being truthful to act on what they're telling you. In other words, I can't just have somebody come in and tell me there's some crime being committed against them if they don't have some proof or if I can't corroborate it. You've got to have some evidence to believe that a crime occurred. And when you've got a complainant like Mr. Paul who's not being
Mr.
cooperative...
President, I need to object to the narrative.
I'll do question.
1 second, members.
I'll do question.
State your objection.
I need to object to the narrative answer. It needs to be responsive to a question.
Sustained.
All right. In addition, oh, by the way, let me ask you something. Well, you talked about when Nate Paul first came to talk to David Maxwell. Remember that?
Yes, sir.
And in that interview, I believe you said that it was just Mr. Maxwell, Nate Paul, and his lawyer, correct?
Correct.
Now, did Mr. Nate Paul, in that interview, provide an oral recitation of what he contended happened?
Yes.
What is your testimony as to whether, if a person comes in and is orally talking to you about what they contend happened, do you consider oral statements as evidence?
I do.
All right.
It's some evidence, yes.
All right. So in evidence, what types of evidence do you as a law enforcement professional want and consider?
Well, there are many types of evidence. There's physical evidence. You could have tire tracks or something like that, fingerprints, DNA, that's physical evidence. You can have direct eyewitness testimony. That is evidence. That is powerful evidence. You can have circumstantial evidence.
Was Mr. Paul providing you eyewitness testimony as to what happened at his search?
He was, in part.
And is that evidence?
Yes, sir.
All right. Now, when somebody comes in, are they supposed to bring you a wrapped up, beyond a reasonable doubt case? Or tell me what you expect them to be doing.
No, that's not the way an investigation works. You get an initial report by a complaining witness or by a police officer who's met with a crime victim or complaining witness, and then you work from there.
Do you consider that information, that initial information, as evidence?
Absolutely.
And then what are you supposed to do as an investigator with that?
You follow leads suggested by that initial evidence, and you see if you can corroborate it, and you see where it takes you. You follow the road. You follow further evidence that you can get.
So when Mr. Paul and his lawyer came to you in that initial interview, or came to Mr. Maxwell and gave their version of what happened, do you consider that evidence that's to be considered as part of your investigation?
Yes, we did, and we treated it accordingly.
Now we move forward to sometime in, I believe you said, into September?
Yes, sir. Now we're in early September, I believe.
All right. And what was happening then in early September?
Well, the first thing that happened was on September the 3rd, Ryan Vassar told me that the attorney...
Objection.
All right,
Hearsay.
without going into what he told you. On September the 3rd, thank you, Your Honor, I'm sorry. On September the 3rd, did you have to become aware of an outstanding proposed contract?
Objection. Hearsay. Same situation. It's derivative of the hearsay.
It's some... let me ask you this. Did you see the contract at that time?
No.
Were you aware, did you become aware of people that the Attorney General was considering to be appointed as outside counsel?
Sometime in late August or early September, yes.
Did you have names of people he was considering?
I got those names on September the 14th.
Whom did you get those names from?
Jeff Mateer.
All right. The two names that you
Mr. President, objection, hearsay. Move to strike. This was a backdoor attempt at getting hearsay in.
Your Honor, he's not testified to any statement. He's talked about information he obtained. Whether or not that is true or not, we don't know. We're not offering it to show that those were the actual two, but what he acted on.
Overruled.
Thank you. Now, when you became aware of these two names that you understood to be, did you do anything in connection with either one of them?
Well, that was on...
Yes or no?
Yes.
All right, when?
Well, did I do anything with those two names?
Yeah.
No, I didn't.
All right. Had you met either one of the two men that you understood who were under consideration?
No, sir.
The two names you were acting on were who?
The names were Joe Brown, a former United States attorney in the Eastern District of Texas, and Brandon Kamek.
Now, did you know anything about the career or past of either one of those two men?
I knew about Joe Brown's career.
What did you know about Joe Brown?
That he'd been a longtime district attorney in Grayson County and Sherman, and had then become the United States attorney for the Eastern District of Texas under President Trump.
So you knew that he was an appointee of President Trump, correct?
Yes, sir.
And did you know what party he belonged to when he was the district attorney in Grayson County?
Well, I didn't know that. I could make an
If you
assumption.
didn't know it, that's okay.
But I didn't know.
That's all I'm asking you. All right. Now, did you do anything as it applied to either one of those applicants?
No.
When you found out after that those two were being considered, did you, in between that early part of September, and what date did you find out?
Well, I found out on September the 14th, those two
You found
names.
out. Did you do anything in response to getting that information?
I did on the 16th.
What did you do?
Well, on the 14th, I'd spoken to Michael Wynn asking for documents. On the 15th, I called him and voicemailed him again with no response to request the documents. On the morning of the 16th, the Attorney General called me into his office.
And what did he want?
He said, what documents are you trying to get from Nate Paul? Write them down on a piece of paper. Give me Michael Wynn's phone number. They're not going to give you the documents because they don't trust you. I'll try to get the documents for you.
I'll try to get the documents?
That's what he said. He said he would try.
Well, let me back up a second. When the Attorney General comes to you, why had you reached out to Michael Wynn before that?
Why had I reached out to Mr. Wynn previously?
In September.
The reason I was reaching out to him
Microphone.
is I was still trying to get all the documents I believe they had, and he would not give me a definitive answer as to whether he'd given me all his evidence.
Did you refuse to do anything further in the investigation?
No, sir.
Were you willing to continue the investigation?
Yes.
And so when you hear that they're about to hire an outside counsel, what was your concern and your position?
My concern was that if Nate Paul wasn't going to cooperate, we shouldn't be doing the investigation. As I said earlier, I thought the whole idea of investigating the federal and state authorities doing this federal investigation on Nate Paul and essentially mounting a counterattack was ridiculous, was highly out of the ordinary, and was completely improper unless there was solid proof of a criminal act, and I didn't have that.
So what were you going to do by trying to get additional arguments as it applied to the hiring of an outside counsel?
Starting on August 12th, when I realized the Attorney General, who initially told me he agreed with me and then did a 180 and came at me in opposition to my idea to close the investigation.
You mean, are you referring to the third meeting?
The third meeting on August 12th.
Okay.
I was concerned the Attorney General was turning against me, that he might fire me because I wouldn't agree with what he wanted. And I was trying to find a way to prove to him that Mr. Paul's theories had no merit, and we had no business taking Mr. Paul's side against the federal authorities who were investigating him for criminal activity.
What was your attitude at that time, Mr. Pendley, about the Attorney General in terms of what was motivating you here?
Well, I felt like he was under Mr. Paul's influence. I didn't know to what extent. That became clear to me as things unroll and as we go forward in time. My concerns that he was either had been bribed or been blackmailed or somehow was being controlled by Nate Paul increased over time.
Well, let's talk about in terms of how you felt about him. Have you ever said anything about in terms of the subject of trying to protect him against himself?
I did tell him that. We had a very long conversation about that.
All right. Well, I'll get to that conversation in a moment. But at
Counselor, excuse me, we're a little past our juror break time. Is this a good time to break?
It is. Thank you.
We'll take a break until 10:50, so 10 minutes before 11. Be back. Thank you. You may step down. You may continue, Mr. Hardin. Not yet. Need a witness. Fail to forget the witness. I made sure all the jurors were there and you were there. I missed him. Mr. Hardin?
Thank you, Your Honor. Now, Mr. Penley, by the way, as we move into the things that happened in the month of September of 2020, did you yourself ever produce any real extensive notes as to what you remember about the events that occurred during that time? Oh, well, not only turn it on, but lean up, okay?
Yes, the answer is yes. I did write notes, and I produced a 7-page memo.
And have you asked, and therefore have with you, if you could have those notes available to you as we talk about the matters that go forward?
Yes, sir, I have them right here.
All right. Now, what I'm going to instruct you and suggest to you is, if at any time you think you need to refer them to refresh your memory, you can refer to them, but then testify from what you believe at the time. If your notes tell you something that you can't remember exactly, you certainly want to be telling the judge and the other side that, okay?
Yes, sir.
Now, let's go forward. I believe you were at the stage of talking in terms of trying to assure the Attorney General you were willing to continue to investigate, correct?
Yes.
And what was your hope that if you continued to investigate, what was your hope that would accomplish?
My hope was I could dissuade him from believing that this investigation had any merit and should be continued.
All right. Now, at that time, were you personally upset with the Attorney General?
No, sir.
What was your mindset as to what you wanted to try to do for him?
I thought he was misguided. I thought he was biased against law enforcement to his detriment. I thought he was too aligned with Nate Paul, whether through friendship or as time went on, I began to believe other things.
I don't want to as time went on, okay? So having said that, we'll get to that. My point is when we're in the narrative. At the end of the day, when you reached out to the Attorney General, can you tell me, after you found out about the fact that he wanted to appoint outside counsel, did you, if we get to the middle of August, at that time, were you aware as who he had decided that he wanted to retain?
Not in the middle of August, but in the middle of September, yes.
All right. Approximately when did you become aware of whom he wanted to do the investigation?
That would have been on the September 14th meeting with Jeff Mateer.
All right. And then once you found out who it was, what was that he wanted to hire, what was the next thing you did in your involvement?
Well, I found that out on the 14th. On the 14th, I also spoke to Michael Wynn and kept trying to get documents. Then the next day, the 15th, I emailed Michael Wynn and left him a voicemail, no response. On the 16th, the Attorney General called me to his office.
All right. Now, when he called you to the office, had you done for 2 straight days been trying to get documents from Michael Wynn?
Yes.
And did you personally talk to Michael Wynn either of those 2 occasions?
I spoke to him on the phone for 5 minutes on the 14th.
What did you tell him?
I told him I needed the rest of their documents. I said, I've realized I don't think I have everything you got from the judge. Would you please give me the documents? And then he promised to get back to me. He never did.
So the next thing you heard about it was on the 16th?
From the Attorney General, the next conversation was the 16th.
And where did you have this conversation? Do you recall whether it was in person or on the phone?
It was in person in his office. And
And how did it come about? I mean, how was it? Did he call you? You call him? What?
He called me.
All right. When he called you, what did he say?
He said, come to my office, I want to talk to you.
When you did come to his office, what happened?
He said, what are these documents you're asking Michael Wynn and Nate Paul for? I want you to write down a list of the documents on a piece of paper.
Wait, stop a second. How would he know that you were still asking Michael Wynn for documents?
Well, I only know of one way, and that would be Nate
Objection,
Paul was
calls for
calling.
speculation.
Well, let me ask you this. Do you know of,
Shane.
excuse me, I'm sorry, Judge. Do you know of any way else that was part of your conversation on the 16th, or really, what was it? Was it the 16th with Michael Wynn?
My conversation with Wynn prior to that was the 14th.
All right. Do you know of anybody else besides you and Michael Wynn that was involved in your conversation asking him for additional documents?
The only other party would be Nate Paul because he told me he was going to meet with
Objection,
Nate Paul.
hearsay.
All right. So, other than Michael Wynn...
Mr. Hardin, hold on.
Excuse me.
Hold on. The objection was hearsay as to what Mr. Nate Paul told Mike Wynn.
I sustained it.
Thank you.
Sorry. I think we were three talking over each other.
Thank you. Thank you very much, Your Honor. Now, let me ask you this. When the Attorney General asked you to write down the names, did he tell you, and the documents, was it the documents he asked you to write down?
Yes.
Did he, go ahead with the rest of that conversation.
He asked me to write down the documents. He asked me for Michael Wynn's phone number. Then the Attorney General told me that they weren't likely to give me any more documents because they didn't trust me. They didn't like the way the August 12th meeting had gone. They felt I was too aligned with Director David Maxwell. And then he said, I'll try to get the documents for you.
Well, have you ever experienced a supervisor telling you that since the person who's asking you to do the investigation doesn't trust you, he wants you to get out of it, and he'll try another, and then he'll go get the documents?
Objection, leading.
I believe.
Sustained.
Let me ask you this. Have you ever had an experience like that?
No, sir, never before.
Well, did he say why he was going to go get the documents instead of you?
He did not say.
Did he offer any support for you in their allegation that they didn't trust you?
No, and in fact, starting on August 12th, he had not supported me.
So now you've got your attorney generals against you on this issue,
Yes.
and you're still, what was your policy or procedure as you were advancing, trying to still continue to find out if you could head off the special, not the special, but head off the outside counsel?
Well, number one, I was keeping Jeff Mateer informed of everything that was going on. I was sharing my views with him. He was my immediate supervisor. And so I frequently talked to Jeff in person or on the phone and updated him on everything I was thinking and doing.
All right. So were you effectively taken out of the Nate Paul investigation after the call with the 14th?
Yes. Later, I realized the Attorney General had cut me completely out of the loop.
All right. But even at the time he did, had you ever indicated in any way that you were not willing to continue to look into the matter if they would provide you the documents they claim to have?
Objection, leading.
That is not leading.
No, sir.
Overruled.
Pardon me?
No, I never told the Attorney General I would refuse to investigate if they would cooperate.
All right. Had you ever experienced before anything concerning continuing, getting off of investigation because you, or in spite of the let me put it another way. Have you ever had an experience in which an investigation continues to try to help somebody who won't cooperate with you?
No, sir. If someone won't cooperate, that's a giant stop sign.
All right. Now, if I want, after the 16th, in your conversation with the Attorney General, when was the next time you had any involvement in this case?
The next time was on the 23rd.
23rd of September?
Actually, let me back up. I had the meeting with the Attorney General on the 16th. One other significant matter occurred on this case that day that related to me, and that was in my email, I received a DocuSign email requesting approval or declination for an executive approval memorandum for an outside counsel contract for Brandon Kamek.
All right, can Your Honor, at this time, I'll move to introduce Exhibit 236. I believe it is not in evidence.
It is not.
I show it's not. I'm going to check with the true person.
Thank you, ma'am.
Can I have one? No.
Any objection?
Briefly, if I may, Your Honor, this document isn't a complete, if Your Honor will take a look at House Managers 236, it is a partial image of a DocuSign report, or what I'll call a completion report, but it doesn't go to the bottom and include Mark Penley.
Your Honor, if I may, this is the cover page, or one of the pages that will reflect what was happening with the document. It's already, there is a draft of it in evidence. I'll get that. If they object to this, then
It's just simply incomplete. We can't see what Mark Penley did and the dates at the bottom of 236.
that's fine. In the interest of time, I'll be glad to
Sustained.
move. Thank you. Now, in the conversation that you had with him on the 16th, the other matter you said that you didn't complete was what?
The other matter on the 16th was I received the DocuSign email.
Right. And what was the significance of you receiving that?
The significance was it was office practice for certain contracts to be approved by a number of people in the chain of command. And since this matter involved a criminal investigation, it was routed through me, and it was to go on to other people. The last signer was to be Jeff Mateer, the first assistant.
Did you sign off and agree to this contract for Mr. Kamek?
I did not.
And on the 16th of September, did you do anything in relation to it?
No, I saw it was there. I knew I wasn't going to approve it. I didn't touch it.
And if you didn't touch it, does anything happen with the contract until you, the division involved, sign off on it?
It should not have.
All right. And then when's the next time you had any contact with anyone about it?
The next time I had any news about the Nate Paul matter was on the 23rd.
And what happened on the 23rd, and what was your contact and with whom?
I had contact with Ryan Vassar. I got word that the Attorney General was asking where the...
Objection hearsay?
It is. You're absolutely right.
Sustained.
You're absolutely right.
Thank you, Counselor, for that help.
Thank you. Thank you, Your Honor. So did you get a talk at all to the Attorney General during this time frame?
Not between the 16th and 23rd, but I did on the 24th.
All right. On the 24th, where did you talk to him?
He called me on the phone. He told me he was at the White House. He said he just left a meeting in the Oval Office, and he wanted me to approve the DocuSign executive approval memo for the outside counsel contract.
What do you remember about that conversation?
I remember we talked for about 10 minutes, and that was the day that I drew the line with the Attorney General that I would not cross, and I never did. I said I would not approve the contract. I said,
hold on.
Object, non-responsive, move to strike.
Sustained.
Hold on. What, just as best you can remember, tell us exactly what and how he said what he did, and then tell me your response to it.
He said, Mark, I'm at the White House. I just left a meeting in the Oval Office. I understand that the executive approval memo is with you. I need you to approve that contract.
At that time, were you aware one way or the other whether the contract had been signed by the Attorney General?
No, I wouldn't expect.
Yes, there you go. Did you know?
I didn't know.
All right. And so at that time, what was your level of knowledge of the status of the contract?
That it was stuck in my email inbox and it had not been approved through the normal office procedure because I wouldn't approve it.
All right. What did you respond to the Attorney General?
I said, Ken, I cannot approve this, and respectfully, I will not. And I told him why.
All right. Would you articulate for the jury exactly what you told him as to why you were not willing to approve that contract?
I told him that Nate Paul and his attorney were not being cooperative with us by giving us all the documents that I believe they had. They had gone to the media. Furthermore, there was no evidence of any crime. We had absolutely no scintilla of evidence that any criminal activity had occurred on the part of the federal agents, the state agents, the federal prosecutor, or the federal judge. And I said, ethically, Ken, I can't proceed with this investigation, and I'm the senior prosecutor in the agency, and if it's not right for me to do it, it's not right for me to delegate it to anybody else. I won't sign this.
What was his response?
He said, well, we'll have to disagree on this. I've got to go to a press conference. We'll talk later.
What was your history with the Attorney General as to how he would handle or respond to areas of disagreement with you and the staff?
Well, by this time, I'd realized he was very passive-aggressive.
And what do you mean?
I mean, he'd say something was okay or indicate he accepted your opinion one day, and then you'd find out later he had gone around you or he was disagreeing with you. But he wouldn't come and tell me that.
So over the months that this had been going on, had you become aware of anything involving Mr. Paul and the Attorney General? And this is as I'm really at the day of the 24th of September. Had you at that stage become aware of other incidents that were occurring, or were you pretty much just knowledgeable about the events that were affecting you?
I had heard a little bit about...
I don't want to hear what you heard,
Okay.
only that have you had heard things.
Yes, I'd heard some things, not much.
But as a practical matter, day by day, was your knowledge of things with the Attorney General and Mr. Paul pretty much generally restricted to the things that you've been telling the jury about that involved you?
Yes, my knowledge was siloed.
All right.
I didn't know about these other issues until later.
All right. Now, on the 24th, when you told him that, and he said, we'll just have to disagree.
Yes.
When was the next time you heard from him?
He called me again on the next day, Friday, September 25th.
And do you know where he was at that time?
I don't know.
And what did he say then?
He said, are you available to meet with me tomorrow?
What did you tell him?
I said, yes.
What happened? So what happened?
I said, can I assume it's about the matter we discussed yesterday? And he said it was. And then we talked about scheduling.
Where did he want to meet and when?
He wanted me to come to McKinney. I told him I had an event to go to in Denton in the middle of the day. I said, I'll meet you before or after. He asked me to meet with him at 2 o'clock in McKinney. He said he would text me a location, which he did later that day.
All right. So then, did you meet with the Attorney General of the state of Texas regarding Nate Paul and the contract for an outside lawyer to investigate? Did you meet with him about that matter on Saturday, September the 26th?
Yes, sir.
What time of day and where did you meet?
The meeting was scheduled to begin at 2 o'clock. I was there before 2. He arrived about 2:20 or 2:15. We met for an hour and 45 minutes.
And when he got there, where did you go? Where did you meet?
Well, he asked me to meet in one coffee shop, a Panera Bread, and I was there. He came inside and let's go sit outside. And he crossed the driveway. There was a Dunkin' Donuts across the driveway that had an outside table with an umbrella, and he wanted to sit there.
So unlike what we're experiencing so far right now in September, was it a September day with more normal weather that was cool enough to comfortably sit outside?
Yes, sir.
All right. And then who began the conversation?
He did.
What did he say?
He said he was frustrated. He said, I felt like I did when I couldn't get Chip Roy to do what I wanted him to do. My staff's not doing what I'm telling them.
Chip Roy was the previous first assistant, is that correct?
That's correct.
All right. Now, when what did you respond to that?
Well, he then went on to talk about he wanted me to approve the contract. He was upset that I hadn't approved it or that Jeff Mateer hadn't approved it.
I want to go back, if I can, to whether or not you did any preparation for this meeting.
Yes, sir, I did.
Tell the jury what you did in anticipation of this meeting.
Well, in all honesty, I woke up at 5 o'clock in the morning, and I felt like the Lord woke me up and impressed upon me that I needed to get ready. This was a serious situation. Again, I felt like my job was in jeopardy. I didn't want to get fired, and I was hoping that I could get Ken Paxton to listen to reason. And so I did my morning Bible reading. There was a verse in there. It said, "Do true justice," Zechariah 7:9. And I wrote that on the top of my notes, and then I proceeded to write out a bullet point outline with all the problems with proceeding with the investigation of the Nate Paul matter. And I wrote down things that I felt like he needed to understand that were a danger to him personally and career-wise.
So, if I may, I'm going to ask if we can show him a copy of the first page, of the notes that he prepared before the meeting. I have marked this as Exhibit 214. It's not in evidence, but I wonder if we have a copy we can show him that's clean. Mine's got all kind of markings on it.
Sir, I have a copy here.
Pardon me?
I have a copy.
I know, but I want to show you one that's got the exhibit.
Thank you.
I want you to look at it, identify it, but I don't want you to testify about what's in it yet. I want you to look and see if that is a true and accurate copy of the notes you prepared in anticipation of meeting with the Attorney General.
Yes, sir.
All right. Would you look at, there's a 2-page notes? Well, it's 3 pages, really, isn't it?
It's front and back copies.
All right.
There are 3 pages.
All right. You went away from your microphone again.
I'm sorry, there are 3 pages.
I've done it much more times than you have. All right. And do those notes accurately reflect your thoughts that you were reducing to writing in anticipation of discussing this subject with the Attorney General?
Yes, sir.
Your Honor, I'll move to introduce. These been produced. Both sides have these. Actually, I would think we received these notes from the Attorney General's office in the production. Or actually, we got them from Mr. Pendley, excuse me.
Any objection?
Yes, Mr. President. These, Mr. Hardin has not provided me a copy of the document, but I'm extensively familiar with it. It's hearsay. These were not notes from a meeting with the Attorney General. These were the out-of-court statements of Mr. Pendley expressed in an outline prior to the meeting. And hence, they are inadmissible hearsay.
Okay, do we have a copy for the attorney, for the court?
Thank you very much, ma'am.
Does the court have a copy? Oh, thank you.
I'm going to sustain the objection.
Thank you. Now, these notes that you have, or these copy of these same notes that we've talked about, Exhibit 214, do you have them up there with you?
I do.
Can you tell the jury in general, set from your own memory, all the things that you planned you were going to tell him?
Yes.
Hold on. I believe that Your Honor sustained my objection to hearsay, and so any testimony from this document would also be fruit of that hearsay.
I didn't ask him to testify from it. In fact, I asked him the exact opposite. I said, simply put them down. Now tell us in your own mind, and if you need to refer to them to remind yourself of something, but my questions to you are directed to what you planned to tell the Attorney General,
right,
in both tone and content for this meeting of the 26th.
Overruled. Continue.
Sir, what I planned to tell the Attorney General was, number one, this was a very dangerous investigation for him to continue. He was a friend of Nate Paul's. Nate Paul was a campaign donor to him. There was no evidence of any criminal wrongdoing. There was no legal basis to continue the investigation. There was no ethical basis to continue the investigation. In fact, I felt it was unethical to continue. I felt that Nate Paul was trying to manipulate me and Director Maxwell and the Attorney General to do an investigation that had no merit, and we shouldn't be doing it. And then I also told him there was great risk to him. This could look like bribery. This could turn into a criminal charge against him. I told him this could turn into a media scandal if it got out. I said, you should not be doing this. Please back away from this. Let me handle this my way. And then I had a section where I wanted to go over with him the practical difficulties of doing the investigation that he wanted us to do. As I explained previously, the issued set of search warrants were still under seal at the federal district clerk's office by federal court order. I had no way to get access to those. The original computer that the forensic experts
Mr. President, I need to object to the narrative testimony. This needs to be responsive to the
Sustained.
question.
All right, so you're telling us what you plan to do. My next question is, did you tell him what you have just testified to the jury?
Yes, I told him all of those things and many others.
And I'm about to ask you about the many others. So let's go now to the 26th itself. You get up in the morning, you write all these things out that you've been testifying about. What else did you tell him in an attempt to persuade him to drop the Nate Paul matter?
Number one, I told him, I don't know Mr. Kampnick. I don't know his experience level. It's my understanding he's never been a prosecutor. I'm not going to supervise him. He told me at that meeting for the first time that Mr. Kampnick had already been hired and was working and had been working on this for at least 2 weeks. I did not know that.
What did you say in response to that?
Well, I said, I won't supervise him. And he said, don't worry, I will.
Well, did you know anything in the background of the Attorney General that would have qualified him to supervise a federal, or not a federal, but a state prosecution investigation?
Nothing whatsoever.
So when you said you wouldn't supervise him, and he said, don't worry, I will, what did he say then?
Well, I think the conversation shifted at that point, and I was trying to tell him, stop Mr. Kampnick. In fact, this was at the end of the meeting. I had 2 recommendations for him. Stop Mr. Kampnick and talk to Jeff Mateer about a way to get Mr. Kampnick paid for whatever he's already done. That was one of the Attorney General's big issues in the conversation. This guy's working and I've got to pay him, and you won't sign the executive approval memo, so I don't have money in the budget to pay him with. And then he threw out, I spent $50,000 on my personal lawsuit last month. And then he made comments about his distrust of law enforcement and his concern about...
What did he say about law enforcement?
He said, you don't know what it feels like to be the target of a corrupt law enforcement investigation. I've spent $50,000 on my case, things of that nature. He made many comments to me, or several, I'll say several, during the course of these months that indicated he had a negative attitude and a distrust of law enforcement.
Did he particularly ever focus on DPS in his negative attitude?
Yes, I've heard him make negative comments about DPS.
Like what?
He doesn't trust the director, and he feels like the DPS ran a corrupt investigation on him in the securities fraud matter.
Did he have the same feeling about the securities board?
I did not hear him talk about the securities board.
All right. Were you aware one way or the other as to whether a representative of the securities board had been involved in a search warrant?
Yes, I knew at least one of their agents was a task force officer with the FBI on the searches.
And do you know who that officer was?
Yes.
Who?
His name is Randy Saban or Saban.
Will you spell Saban or Saban for the court reporter?
Sabban.
How would he know? Do you know who? Let me back up. In your meetings with him, back starting in July and into August, in one of those meetings, was there a conversation with him and these are the 3 meetings we talked about,
Yes, sir.
in which he specifically addressed the issue as to whether Agent Saban was actually the applicant for the search warrant?
Objection leading.
Did you ever hear?
Sustained.
Did you ever hear anything from him during those meetings with you about Agent Saban?
Yes, sir. You talking about Nate Paul's comments?
Yes.
Yes, I did.
And in the meetings, did you ever hear him say that Agent Saban was the affiant in the application for the search warrant?
Objection. Hearsay. As I understand this to be Mr. Paul's comments, offer for their truth.
Sustained.
Did you discover at any time that Mr. Wynn and Mr. Paul knew the identity of the agent that signed the application for the search warrant?
Objection. Hearsay. If necessary, I will take this witness on voir dire to establish that the basis for his knowledge is hearsay.
Sustained.
Did you ultimately discover that these folks in your meetings knew who had been the applicant in a search warrant that was sealed, application that was sealed?
Same. Objection. Hearsay. And I'm happy to take this witness on voir dire to establish that.
I asked if he ever became aware.
It's sustained.
All right. Now, would anyone be able to know the identity of the agent that signed the search warrant, the application for the search warrant, if they had not had access to a sealed document?
Objection. Assumes facts not in evidence and calls for this witness to speculate on that topic.
Let me ask you this. Did you review the grand jury subpoenas that were ultimately served by Mr. Kamat?
Yes.
Did you see the name of Agent Sabat on there?
Yes.
Would Agent Sabat's identity be known to anybody that had not seen the sealed document?
Objection. Calls for speculation again.
To your knowledge.
Sustained.
Now, do you remember back when the presentations, you make it a PowerPoint presentation they brought to that meeting?
Yes.
And do you recall what that PowerPoint presentation was called?
Yes, sir, I do. It was called Operation Longhorn.
Was that PowerPoint presented to you by Mr. Wynn and Mr. Paul?
Yes, Mr. Paul specifically.
All right. Can I have the exhibit number, please, of the PowerPoint? It's in evidence. In fact, I think it was introduced by the other side. Oh, that's okay. I think she's bringing it up.
It's in evidence.
Could you put up exhibit 152, please? Now, go to the next page, please. Do you recognize this exhibit, please?
I do. That's the document Mr. Paul gave me at the August 5th meeting.
Fine.
One moment, please. Can you confirm, Mr. Harden, that everything has been redacted from this was the piece of evidence that we paused to redact information?
I want to make sure.
I saw 2 thumbs up from Stacy.
Two thumbs up says it has been, Judge. And we've done that in light of the presentation. Thank you very much. In this search warrant, if we could, search warrant discussion rather, it talks about when it was executed, all right? And it says down at the bottom, I'll read it to you. According to the filings with the court in the Western District of Texas, each of these warrants was signed and issued by Judge Mark Lane at 10 a.m. Is Judge Mark Lane one of the officials they wanted investigated?
Yes, he's a federal magistrate judge in Austin, and they wanted me to do a criminal investigation on him.
All right. Next page, please. Now, this sets out, does it not, that they have discovered through a forensic analysis of the metadata and what we've been talking about before. And it was emailed and given them by Alan Bew to the council's Chuck Meadows and Ayer Board. Those people were back in August 14th of 19 were representing Nate Paul, correct?
Yes, my understanding was at that time he was represented by Austin attorney Jerry Morris and the Dallas law firm of Meadows and Collier.
Next page. Now, they point out to you that below is pertinent to how we discovered through forensic analysis in the document that had been mailed by the federal prosecutor. Alan Bew is the federal prosecutor, right?
Yes, he is.
Okay. Then they give us the data that they've got there as to where this server is located. Can I have the next page, please? They have the addresses where the search warrant was to be executed on, right?
Yes.
Next page. Now, do you have any idea how they would have all this information? Now, answer yes or no first.
Objection calls for speculation.
Do I have any idea?
Hold on, Mr. President.
The question was knowledge. I just have to add any knowledge of it.
If you can, answer yes or no.
Yes, I have some knowledge.
Can I have it talks, does it not, about Mr. Saban, does it not?
It does. It mentions his name at the top.
All right. Do you know if he appears in any of the document of the original search warrant itself? Have you looked at that to see of the part that was public, if his name appears at all?
Objection. Lack of foundation for this witness's personal knowledge of that.
I asked if he has read the search warrant
Sustained.
that was public. Let me try again, Your Honor. Have you looked at and reviewed the search warrant that was public information, is and was the search warrant that was ultimately given to the attorneys of Mr. Paul after the search?
Yes, sir.
On anywhere on that search warrant, does it mention the name of Mr. Saban?
No, sir, it does not.
Next page. It lays out, does it not, the things that they're complaining about, right?
It does. And these were things we told them we had no jurisdiction over.
Next page. Now it has people of interest. And are these people that they wanted you to investigate?
Yes, they wanted us to investigate each of these people.
Would you go down the list and see why, and tell us what they told you, or what these people they were requesting to be investigated roles were?
Yes. Randy Saban was on the task force. He was at the search warrant that was executed at Mr. Paul's residence. Mr. Paul stated he had personal conversations with him during that search. Agent Joy of the FBI, he was mentioned. I don't know which location he searched. They represented that Ms. Sobravia Dent was a courtroom deputy clerk to a United States magistrate judge.
Yeah, can you explain to us why in the world you were supposed to investigate a courtroom deputy clerk of a federal magistrate?
I have no idea how there's a state interest in doing that. The federal authorities have full control over the federal district clerk's office, and their law enforcement and their inspector general's office has the full ability to go in and get all the documents needed to do such an investigation. We did not.
All right. Now, if I have the next page real quickly, let's move through this. They give you information. This man that they want you to investigate was actually a member of the board of the agency that had brought the charges against the Attorney General, correct?
Yes, I became aware of that.
All right, that's it. That's all I need there. Did it have personal data about him that has been extracted from this?
Could I see that page again?
Yes. No, yeah, the page. If you know. If you don't know, doesn't matter.
And I'm sorry, could you ask the question again?
Let's move on. You can take that down, but there were code words in this thing, weren't there?
Yes, there were.
Well, did you have any idea what they were or what they were supposed to represent?
Oh, Operation Longhorn.
Hold on. We're on top of each
Excuse
other.
me, try not to talk over each other for the court reporters.
Yeah, absolutely. Thank you, Judge. Your Honor. Were there different little code names like Longhorn and other things? You remember what any of them were?
Well, the only one I knew at the time was Operation Longhorn. I've learned some since this summer.
All right. Now, if I can, at the end of the day, on the 26th, when you were talking to him that Saturday, you've talked about almost 2-hour conversation.
Yes.
Do you recall at the end of the conversation, do you recall anything else that the Attorney General said to you in response to your urgings that you've described to the jury?
May I review my handwritten notes to refresh my recollection, because there were many other things discussed?
Yes, don't read from the notes, but you can look at them and see if that refreshes you.
All right.
To be clear, Mr. President, I do not know what notes he possesses up at the stand, and I would like to at least be able to review those.
I thought we gave him 214. If we did not, could we please?
214 are not notes, Mr. Hardin. That is his outline from before the meeting. So if he's using that to refresh his recollection, he will be using a document that has been overruled as hearsay.
Which, in more years than I'd like to admit, a witness regularly does. So that is not
an expert witness.
Excuse me, that's not a legitimate evidence. This man has brought up his notes. They're not in evidence. They've objected to him. He is certainly allowed to look at documents not in evidence to refresh his memory. He just can't read from them.
Would you show counsel these notes?
And Mr. President, what I would like to do is take this witness on voir dire to establish that, wait, hold on a second. You said 214, this is 216. So you're asking him to review 216? These are his notes, 216 is.
Pardon me?
Okay.
I've got a bunch of voices around
Got a lot of
here.
people
I'm
talking
sorry.
to you.
Go
Are you
ahead.
asking him to review 216?
You're right. You're right.
These are his notes.
Excuse me, just so the court knows what we're talking about. 214 is the document that he planned, of what he planned to talk about. He's right. 216 is what I'm asking him to look at and what he was about to look at. So I just gave you the wrong number. If you want 216, well, if you have 216s produced, do you have
No objection
216?
to 216. I plan to introduce it as well.
All right, neither one of them to answer your question earlier.
Have we settled this, counselors? No objection
I believe we have.
to what he's going to read from? Okay.
All right. Now, if you reviewed your notes from the day after, did you type up those notes, write those notes by hand before or after, during, when did you do it, the meeting?
I wrote these notes when I got home that evening after the McKinney meeting, and they're handwritten.
Have you reviewed them?
No, sir. If I could have a minute, I wanted to be sure I had permission
Go ahead.
to. Yes, sir. I've reviewed the notes.
All right. Was there anything else you called? Does that help refresh your memory as to whether there was anything else in your discussion that the Attorney General said?
Yes, there were several things. Number one, I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. And what was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
All right. Anything else you recall he said in that conversation on the 26th?
We discussed the fact that he had taken Nate Paul personally to the Travis County District Attorney's Office.
Did you ask him, or did he volunteer that?
I told him I had learned that. By this time, I had heard that.
And what was his response?
His response is, well, I didn't request the investigation from them. They had a conflict, and they asked me if I wanted it, and I said yes.
All right. What else?
I told him there was no state basis for believing there was any state offense, and he kept bringing up Nate Paul and Michael Wynn's complaint that the agents hadn't left a copy of the search warrant at the residence or the office, allegedly. I don't know if that's true or not.
Is that something he wanted the Attorney General's office to investigate about?
Apparently he did, because he told me that the fact that I didn't think that was serious, which I didn't, and I explained to him why. That's a federal rule of criminal procedure. That's not even a misdemeanor statute. And that's something the magistrate can deal with very easily if it's true. But he said that was a red flag to him that indicated I was too biased in favor of law enforcement.
How was the tone of this conversation?
He was frustrated, and that was the most, it wasn't a hostile conversation, but it was a difficult conversation.
How did the conversation end?
I told him that I was trying to be a loyal subordinate and a friend, and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds, and there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants. And if I'd called the U.S. Attorney's Office and said, can I see your file with the original search warrants, they'd have laughed and hung up the phone, and I would have understood why. All that was under privilege at the U.S. Attorney's Office. They had an active investigation of Mr. Paul.
So how did when the conversation was over, what was said between the two of you as you parted?
The way I left it was I made two recommendations, which he didn't object to and he didn't disagree with, but then I found out later he obviously didn't act on them. Number one, I said, stop Camet from working and talk to Jeff Mateer and figure out how to pay his invoice, and don't let him work anymore. Number two, let's you and I meet with Jeff Mateer. I can explain some options we've got. I don't think they're great options. You may want to pursue them, but I think they're a risk to the office. One of those options was calling the United States Attorney's Office, talking to one of the supervisors, see if they would just assuage our curiosity and tell us if there were any changes between the returned version of the search warrant and the issued version.
And what did he say?
He didn't say anything to that. He just said, well, I've got to go. I've got a dinner to attend. But he didn't agree or disagree.
After that conversation on the 26th, without going into what you said, did you call Jeff Mateer and update him?
Yes, immediately after I left the meeting.
And then after the 26th, when was your next involvement with anything having to do with Mr. Paul?
That was on the morning of Tuesday, September 29th.
And without going into what people told you at this time, what happened on the 29th?
Mr. Kamek and Mr. Wynn served a search warrant in the name of Brandon Kamek, Special Prosecutor, Office of the Attorney General of Texas, on Independent Bank in Round Rock.
What was your reaction to that?
I was apoplectic.
Why?
Because it appeared to me that Mr. Kamek was working on behalf of Nate Paul's civil litigation interests and serving a criminal process, a grand jury subpoena, on either a bank or a party to one of his civil lawsuits. He was seeking discovery through using criminal process.
Had the Attorney General ever said anything to you in his conversations that Mr. Kamek was a special prosecutor?
No, at this point in time, the only thing he'd ever told me was that he was working and beginning to gather information. He never told me a title.
All right. What happened on the 29th when you found out that a community bank had been served a grand jury subpoena?
Well, Jeff Mateer called a meeting in his office at 3 o'clock for the deputies involved that became the whistleblowers.
At the end of those conversations, did y'all make plans to go to the government?
No, not that day.
All right. And then what happened on the 30th?
On the 30th, in the morning, we got another message that a second subpoena had been served, this time on Amplify Credit Union in Austin.
And what was your reaction to that?
I was even more apoplectic. I was furious that this was going on and the Attorney General was allowing it.
And what was wrong with serving a grand jury subpoena on Amplify Credit Union?
Because again, this looked like Nate Paul was using the power and authority granted by the people of Texas and this legislature. He had turned it over to Nate Paul for Nate Paul to go after his business opponents.
I asked you what was his objection to it. Did you have, I believe, let me ask you this. When you were so concerned, what was wrong, in a very succinct way, please, what was wrong with what they were doing?
Number one, these banks had nothing to do with referral number one, which was the only referral we knew about. Number two, you can't use criminal process to conduct civil discovery, and that's what it appeared was going on, because Mr. Paul's attorney was with Mr. Kamek at both banks.
In all your years, first of all, have you been involved where the prosecutor was the one serving the grand jury subpoena?
No, sir, I haven't heard of that.
Who is usually the one serving grand jury subpoenas?
A deputy, a federal marshal, depending.
And then, have you ever heard of the lawyer for the person bringing the complaint, who's also under a federal investigation, accompanying the prosecutor serving the subpoena?
No, in fact, the Code of Criminal Procedure doesn't
Not
allow
responsive.
that.
I'll get to that.
Sustained.
What is the law in terms as to whether or not a person representing the complainant can be involved in that circumstance?
The law says you can't. An interested party cannot be involved in serving a grand jury subpoena.
Now, after this, on the 30th, did you, as a group, ultimately go to the FBI?
Yes, after we learned about the second grand jury subpoena being served, we were extremely concerned as a group. I was extremely concerned personally, and we decided we had to go to law enforcement.
And why did you go to law enforcement?
Because this had to be stopped. The Attorney General obviously wasn't listening to anybody. He had turned Mr. Kamek loose. We didn't know what Mr. Kamek was going to do. It appeared that Mr. Paul was controlling this
Object to the narrative and speculation.
I asked him why he went. What was in his mind? Let me ask you this. What did you expect the consequences being of your going to the FBI?
I feared we would get fired.
And was that the sense and mood of the whole group?
I think so. I think we all knew this was an incredibly dangerous and unique but outrageous situation. We were the only ones that could stop it, and we had to.
When you went to the FBI, did you take any documents?
Did not take any documents.
Would the documents all been the property of the AG's office?
Yes.
So is that why you didn't take any documents? Just
Objection
yes or no?
leading.
Why did you not take any
Sustained.
documents? Excuse me. Why did you not take any documents?
I didn't take any because I felt like we were making the initial report based on our eyewitness personal knowledge of what we believed at that point to be criminal behavior by the Attorney General.
And so when you went, did you take evidence with you?
I took my personal knowledge and the others took theirs.
All right. Is that evidence?
Absolutely. We were eyewitnesses.
So if a person is the victim of an aggravated robbery and reports it to the police, would it quit being evidence if just they report it as opposed to taking documents?
Objection leading and relevance.
Their personal experience.
Hold on. Sustained.
What did you take with you that first of all of y'all going,
Yes.
did you take evidence in the meeting of evidence?
Yes.
What did you take with you that was evidence?
our personal eyewitness knowledge, our personal experiences, our personal conversations with the Attorney General, our personal experience of him pressuring us to do things that were improper, unethical, and illegal.
In your experience, how often is the initial report by a citizen of something that they consider criminal conduct, how often is that where the witnesses come in without any documents just to tell you what they believe, they saw, they know that they think is improper? How often is that the way it gets to your desk?
Objection, relevance.
Oh, it's very relevant.
Overruled.
Yeah, thank you.
That is very common.
So if a person walks in to report what they believe is a criminal offense or improper conduct that should be investigated, do you send them away if they don't have paper?
No, sir.
So what is your testimony as to whether or not, how much, from how many people, evidence was presented to the FBI with the request for them to investigate?
The meeting lasted almost 4 hours. It consisted of us sitting around a conference table with 2 FBI agents, and our attorney, Johnny Sutton, was present. The FBI agents asked us to go around the table in turn, starting with Jeff Mateer, and tell our entire story. And as I said, it took almost 4 hours. That was 4 hours of eyewitness personal knowledge from people directly involved with the Attorney General, the events I've described, and the events the others were involved in, the others being the whistleblowers.
Mr. Penley, after that meeting, did you yourself file any documents to attempt to or to quash the subpoenas that you had learned had been filed?
Yes.
Yes or no? That's all I'm asking you.
Yes.
And why was it that you filed a motion to quash those subpoenas?
Because those subpoenas were improper and they had to be stopped.
All right. And what was improper about those subpoenas?
Number one, Brandon Kamek was not a special prosecutor, yet that's how he represented himself to the Travis County DA's office.
All right. Now, at the end of the day, after those subpoenas were quashed, what happened with you in terms of whether or not you went to the media or anything else? Did you?
I've never gone to the media other than I think our attorneys filed, may have written in an editorial sometime earlier this year.
Was at that time, what was the Attorney General's response in the media that you folks felt obligated to respond to?
The following week, the week of October the 5th, the Attorney General's office issued 2 press releases that made negative comments about the group of whistleblowers, claiming that we had impeded an investigation, claimed that we were rogue employees, and later the Attorney General claimed we'd even committed crimes.
What was your group's response to that?
Well, everybody was outraged.
All right. Let me ask you this. Are you one of the plaintiffs in the whistleblower lawsuit?
Yes, sir. I'm one of 4 plaintiffs.
Why did you decide to sue?
I sued because I was damaged by the office's actions in violation of the whistleblower statute.
And what financial impact did this all have on you?
Well, that had a big impact. After, number one, I was put on investigative leave on October the 2nd by order of the Attorney General. On November 2nd, a month later, I was fired illegally under the Whistleblower Act. I was given ridiculous reasons for the firing.
What were the reasons you were given?
The reasons I recall, and these came from the new first assistant who got rid of all 8 of us within 45 days. He said I'd lost the Attorney General's trust. I violated.
Hearsay.
I asked for reasons he was given for firing.
Overruled.
He said I'd lost the Attorney General's trust, number one. Number two, he claimed I used an insubordinate tone when he demanded to have my cell phone handed over to him so he could examine it without a search warrant.
What is that? What is that about?
He claimed there were public information requests to the Office of the Attorney General, and he demanded to see my text messages.
All right. Now, did that all become part of litigation later?
That became part of the litigation. And then the third reason was,
What was the third?
reason number 3, he claimed that I had violated a direct instruction from the Attorney General when I filed the motion to quash and when I sent a cease and desist letter to Brandon Kamek, and that is untrue. He claimed that on September 16th, when the Attorney General asked me for information about the documents I wanted from Michael Wynn and Nate Paul, at the end of that meeting, the Attorney General said, "Don't do any more on this." The context was, don't ask.
That's okay. Hold on. Okay. I really, really want to finish up here with you to ask you this. After all you've been telling the jury about, after all you've been doing differently, would you do anything differently?
No, sir, I'd do the same thing all over again because it was the right thing to do and the only thing we could do, other than stand by silently and let crimes be committed. The agency was being abused, the laws were being abused, the behavior and the conduct of the Attorney General of Texas was outrageous.
Object to the narrative.
Sustained.
I'll pass the witness.
Mr. Little?
Thank you, Mr. President. Just for planning purposes, when do you intend to break? I believe it's 11:55.
Take a break at 12:15. Does that work? Or would you prefer to take the break now and start anew after lunch?
I'd like to take a few minutes and get started, if we might. Thank you.
You're a witness.
Mr. Penley, I'm going to hand you some of your notes here so that you've got them. You need something, Rusty?
I did just get out.
Left your cup of water? All right. Documents for you.
Thank you.
At this time, Mr. President, I'm tendering to the witness exhibits 1009 to 1021. This is a series of notes in Mr. Penley's hand. May I approach?
Yes. Have they already been admitted or you're admitting them? Okay.
Now, Mr. Penley.
Do they have a copy?
They do. I've handed them to Mr. Hardin. We move for admission of exhibits AG 1009 to 1021.
Any objection?
Yes, I think these are, to repeat a famous objection, these are all hearsay, every one of them. They're the same kind of thing we offered to introduce to him, and he objected to his hearsay. If he withdraws his objection to the notes of our witness, then I'll withdraw my objection to these. Otherwise, sauce for the goose and the gander and all that jazz works.
Mr. President, may I respond?
Yes, you may.
These notes that I've handed to Mr. Penley are notes of his present recorded recollection from the meetings with the Attorney General in various formats. Mr. Hardin has already offered House 216, which is his notes from September 26. These are all of Mr. Penley's notes, and they are extensive.
I'm sorry, I don't know how that's any different than what we just talked
I'm
about.
not sure I understood your reply.
Recorded recollection is an exception to hearsay, and these are his notes, just like House 216, which was admitted and offered earlier.
If I may be heard, I think his memory is incorrect. 216 was not admitted. I asked and he objected to hearsay.
I remember he did not object. He said they were going to use those notes, is my recollection. We can check the
That's right. And it
record.
was offered and admitted.
Offered and admitted. He did not object.
I think that was 214.
No, that's when there was confusion between 214 and 216.
Yes.
So the 214, if my recollection is correct, were the outline before the meeting, and 216 is
You're
the
absolutely right.
recollection after the meeting. And he did not object to that.
All right.
I may have not, maybe the court did not admit them into evidence, but you did not object. I remember you saying you were going to use those.
That's right.
In cross.
That's fine. If it's admitted, then that's great. If he wants to admit these under the same theory, then I have no objection.
Great.
Okay, so these notes are admitted under evidence, which the numbers are
1009 to 1021.
1009 through 1021.
Thank you. Now, Mr. Penley, just to be clear, we need to clarify something for the ladies and gentlemen of the jury, and I'm almost positive you have the answer. You conducted an investigation, right?
Yes, I did.
And it wasn't a review, right? It was an investigation.
Technically, the office called it a review. I'm using the term investigation the way I mean the term investigation. We met with a witness, we looked at the evidence they gave us, we drew a conclusion, and that was the end of it.
Sounds like an investigation to me. Don't you agree?
I do. It's semantics.
You just never opened a file, right?
No, I didn't open a file. There was no basis to open a file and pursue any charges.
David Maxwell, well, you don't, hold on a second. Let's be super clear for the jury. You don't, if you could, Mr. Harden, he's beeping over there. Let's be clear for the jury. You do not need to bring charges to open an investigative file at the Office of Attorney General, right?
No.
And you didn't open a file, and David Maxwell did not either, did you?
I know I didn't open a file.
Well, you know David Maxwell didn't open a file either, did you?
I've heard that.
Yes. And to be clear, this was not an inquiry. It was not a review. You call it an investigation, yes?
That's my term. David Maxwell's term was review.
There was nothing illegal about conducting the investigation that you conducted, was there?
We didn't take any illegal actions, no.
Object not responsive, just so I can get a yes, no.
Sustained.
There was nothing illegal about the investigation you conducted, true?
That I conducted, that's true.
That anyone at the OAG's office conducted, true?
No.
Let's be clear about this. Did you see Mr. Maxwell break any laws in conducting this investigation?
No, I did not.
Did you break any laws in conducting this investigation?
Absolutely not.
Were you asked to do anything illegal?
Yes.
Tell the ladies and gentlemen of the jury about that.
We were asked to obstruct a federal investigation. That's a federal felony.
Interesting. Are you aware of Fifth Circuit and Ninth Circuit precedent that says you cannot obstruct an FBI investigation because it is not an official proceeding, Mr. Penley? You're familiar with that authority, aren't you?
No, I'm not familiar with that authority.
Well, you worked at the U.S. Attorney's Office for 17 years. Surely you came across the fact that you cannot obstruct an FBI investigation as it is not an official proceeding, right?
I'm sorry, I lost your question there. What are you asking me?
Yeah, in your 17 years working at the Office of the U.S. Attorney in the Northern District of Texas, did you ever come across the precedent, legal precedent, that one cannot obstruct an FBI investigation because it is not an official proceeding?
I was never presented with that issue, and I was there 16 years, not 17, just to be correct.
Did you ever once in your 16 years prosecute obstruction of justice relative to an FBI investigation?
No, that was never presented to me as a case.
Not one time, true?
No. No, I mean, your statement is true. I did not do that.
I want to be clear, you gave us a timeline. We're going to go back through the timeline in detail in a minute. But in September, you became concerned that the Attorney General might fire you, correct?
I think I became concerned after the August 12th meeting when he did a total reversal on me.
Sustained.
You testified on direct that in September of 2020, you became concerned that the Attorney General was going to fire you, true?
I don't agree with the way you're wording the question. I was concerned in August and September.
I'm only asking you about September.
Okay.
I'm going to ask you about August in a minute. In September of 2020, were you concerned the Attorney General was going to fire you?
Yes.
And isn't it interesting that you came up with these theories of your boss's criminal escapades after you thought he was going to fire you, right?
What theories are you talking about, sir?
Well, you and David Maxwell got together and you asked a series of questions, right? Is Ken Paxton being bribed was one of them, true?
Yes, we wondered about that.
Is Ken Paxton being blackmailed? That was one of them, true?
Yes, we discussed that.
Does Ken Paxton owe Nate Paul any money? True?
I'm sure that's something that came into my mind.
Does Ken Paxton or does Nate Paul have some kind of information on Ken Paxton? That was one of the things you talked about, right?
It's certainly something I thought about.
But you only started talking about those things with David Maxwell when you after you became concerned that Ken Paxton was going to fire you. True?
No, that's not true.
Councilor Benholju, do we know where this music is coming from, bailiff?
The bagpipes?
Yes.
It's coming from the rotunda. I think now probably would be a good time for a break, Mr. President.
We will take a break now. We will return here at 1 p.m. sharp.
Mr. President, should I leave the exhibits just sitting here?
Yeah, why don't you turn the face down?
All right. Okay, all right.